The on button.
Turn my mic on. Did it do anything?
Testing, testing.
No? Okay.
Not that I can see. There's like an electronic system here. Is the county ready? It, it's 9 o'clock. All right. Good morning, everyone. The time is 9 o'clock. I hereby call this Citrus County Code Compliance hearing for May 2025 to order. So for these hearings, we normally follow an agenda, and the first item on the agenda is the call to order. We just had that. The second item on the agenda is the pledge to the flag. So I'd like to ask if you'd stand and join me for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
The next item on the agenda is dealing with the minutes from the prior hearing from April. I've reviewed the proposed minutes. Are there any suggested deletions, modifications, objections to the minutes as currently formulated? All right, seeing and hearing none, I will approve subject to 2 typographic changes on page 1, removing the 20 after the 16 for April 16, 2025. And then on page 4, Rodney Worthington without a T the second time that it occurs. So I'll sign that and approve it. That's it. Okay, no updates. All right, so ladies and gentlemen, this is the first time, first of all, that we've had a code compliance hearing in the courthouse here and in these chambers specifically. So I'd like to ask for your patience as in case there's any kind of kinks that need to be worked out. But I'd like to give you an opening statement that tells you a little bit about this hearing. My name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by law, but what it means is that Citrus County has hired me to preside over this hearing. What I'm going to tell you during this opening statement applies to all of your hearings, so I'd appreciate your attention. When your case is called, please come forward. You will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call the case, and I will allow the county to first present its case. You will then have an opportunity to cross-examine any of the county's witnesses, and you will have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case to me. I will also ask whether or not you are contesting the violation, whether or not you're even arguing that a violation exists. If you do not contest the violation, I'll assume that a factual basis for the violation exists and proceed to ask how much time you need to fix the violation or just to work with the county. This will help save time for yourself and others. Now, you are by no means required to do this. If you oppose the case or simply want to be heard, you do have that right. I bring this up particularly for this hearing. I've been told that this is going to be a long one. There are more cases than usual set for this. So it may be that if we're not done by, say, noon or 12:30, we may take an hour break for lunch, 45-minute break. The implication is simply that, in short, this hearing could take all day. So if you're not opposed to the relief, if you're willing to work with the county, let us know and we'll talk it out. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak. And if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witnesses must remain civil, and you must not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, The law requires that I give you a time to comply before a fine begins. You must fix the violation by that date, or a fine will accrue for each day that you remain in violation. The law allows Citrus County to impose that fine as a lien on your property. The county has the right to foreclose on that lien or to seek a money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their rights or responsibilities to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate these into all of my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, that cost will remain minimal. But if you do not timely fix the violation, you will be responsible for additional costs. Although it has only happened a few times in my years as a special master, I may continue your case if I find a need for further evidence or argument. You do have the right to appeal any order that I make today as provided by law. Thank you.
First case on the day's agenda, Data Holdings LLC, case numbers 2024-846 and 780, Code Officer Alan Jonason, expert on the case, Land Development Director Joanna Coutu, pages 16 and 17 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Good morning. All right, so I think we're here on your motion, Mr. Hartley.
That's correct. This one's a little bit different, I believe. It is my motion, a motion for an extension of time to comply with the Special Master's order that was entered in November. So I believe I would have the floor here. As we stated, in compliance with your order, we do need more time to comply. This case came about, it was 3 separate parcels and 3 separate code cases that my client owns. It was the result of a gravel parking lot put next to a clinic that was done without a site improvement plan. One included a driveway that went out to the rear portion, and that one we're given a one-time fine, and it was unabatable. So we are looking to possibly get that access back. But that case has been closed. So we do still have the 2 open ones, which include the gravel parking lot. We have been working since November to try and get a site improvement plan. In looking at this case, I believe the presumption was made, and please correct me if I'm wrong, that a site improvement plan could be obtained for the improvements as they exist. In working with the engineers, that's just not the case. We do have to put in additional drainage areas. We have to work with FDOT as well as Swift Mud to be able to bring this up to
Meaning
compliance.
that you can't solely work with Citrus County in order to comply with what the county wants.
That's correct. On Monday, in compliance with the Special Master's order, we did deliver several exhibits just showing various emails, versions of conceptual plans, an improvement plan or improvement timeline to date, and as well as an improvement timeline moving forward of what we think it's going to take in order to get this finally resolved. I know we have a heavy docket today. We can go through each of these exhibits.
I don't think this will take long. I would like to ask the county's position on the introduction of what Mr. Hartley sent as proposed exhibits as evidence. In other words, I'd like to have them either be a part of the record or not. What's the county's position?
For purposes of the extension only, we have no objection. For purposes of the extension only, we have no objection to them coming into
And that's how I would
record.
receive them.
And that's how they're being offered.
Oh, yeah, right. So, all right, then I will, I think it's exhibits A through like K or?
A through U.
U, okay. So A through U are admitted as evidence for the purposes of this, the relief requested. And I have reviewed those. What is the county's position on the relief requested?
If I'm reading the timeline correctly, are you asking for an extension until May of 2026?
Our motion, we asked for a 6-month extension from the deadline, which would, I believe, take us to November of the upcoming year. And that is something we should address, is that's for the site improvement plan. The actual improvements that will be required, that we expect to be required as far as the DRA, won't be completed until after that time. But if obtaining a site improvement plan by itself would bring us into compliance with the special master's order, then I believe a 6-month extension would be appropriate.
What's the county's position on whether or not the site improvement plan alone abates the violation?
For the special master's order, it indicates that just obtaining the site improvement plan is one of the 2 ways to bring these cases into compliance. Both of these cases may be brought into compliance also by just removing the gravel parking. So
I understand.
it is a way to come into compliance, and I could understand based on his emails why they would request an additional 6 months. We would just request they remove the gravel, which could probably be done in a weekend, and he could resolve it much, and still, he can still get the site improvement plan and still do everything, but to actually comply with your order,
What's the county's position on the relief requested?
we would request it, he just remove the gravel, which could be done much faster.
My
and
question is a little more simple. They've requested an extension of...
would object.
You object?
Yes.
All right. I thought that the documents that were submitted were persuasive, if it matters, as to whether or not a good faith effort's been made to comply. I mean, obviously, we can also tell from the emails, not everyone's happy about what's going on, and I understand that. But I feel like it's reasonable, based on the representations made in the email, to grant the extension. In other words, the main objective of code compliance is compliance. And it sounds like there is potentially a traffic issue over there in the evidence. So I take that into consideration, and I'm inclined to grant the motion. So I grant it.
Thank you, Your Honor.
Thanks. Now, is this for both the data holdings cases? Did we call them
I
both up?
believe it was consolidated
Okay,
per
all right.
your order.
Thank you, Mr. Harley.
Thank you.
Next case today, Michael R. Novich, case number 2024-2133, Code Officer Julie Wilkinson, page 36 of your agenda.
Michael Novich.
Good morning.
Good morning.
All right, now, first, we took this case up originally months ago, and I thought that I would be ready with a ruling at the April hearing. I apologize for not having it ready at the April hearing. I did feel that I needed further briefing on this case. Before I issue the ruling, is there anyone from the public who wants to be heard on this case? All right, I don't see anybody. Mr. Novich, is there anything else you want to offer before I issue a ruling? Or you had an opportunity to file a brief and you chose not to file the brief, correct?
That is correct. My goal is also compliance, as you said earlier. My goal is also the nature aspect here in the Nature Coast, and I do have faith in your decision, so let me have it.
Well, it's the first time for everything. So is there anything else the county wants to put on the record? Okay. So I am going to find in favor of the respondent, Mr. Novich, and the reason is that this is a peculiar piece of property. I'll issue this order in writing, but I think that the county's brief was excellent, to be honest, and I don't know if I would have come to this ruling had it not been for the county's excellent brief, but something in the county's brief indicated, and I agree, that the county owns the property subject to the violation. So not all the time do you have a right-of-way where the county actually owns fee simple the property by dedication or otherwise pursuant to a plat. That is the case in this plat. And most of the time what we see are rights-of-way that it's more like an easement granted over property that the property owner would own. But here it's actually the county's property, undisputed. And that means the county can do whatever it wants with that property. The county can go dig up that mulch. It can go do literally whatever it wants to remove or what have you. But I want to read for the record Section 1800B, which talks about liability under the LDC. And this is a case brought by the county pursuant to LDC 7320A. The owner, tenant, or occupant of any land or structure shall be presumed to know of activity occurring on such land or in such structure, and thus may be charged with a violation of this code or any violation found on any premises subject to this code. Based on that, I almost think the county would have to cite itself. In other words, it's the owner of the property. Mr. Novich is not the owner. I think that there's the other side to the coin, unfortunately, Mr. Novich, is the county can do what it wants on that property. Yeah, I mean,
And I welcome those bulldozers. I've got time and lemonade. We'll watch you guys work.
okay, all right. So that's going to be my ruling, and are there any questions?
May I put something on the record?
Yeah,
For the record, the county's interpretation of 1800B also includes the second half of that paragraph, which states, where an architect, contractor, builder, agent, or other person who appears to have participated directly in a violation of this code, such person may also be charged with a violation of the LDC. The county's position is that that second sentence allows us to charge Mr. Novich with this, as he is the violator who actively participated in the violation on this property, which is the county's basis for proceeding with this.
and let's address that. I completely disagree. So where it says architect, contractor, builder, agent, or other person, it clearly contemplates working with or on behalf of the person described in the first sentence. None of that was proven by the county, shown by the county, articulated in any way by the county during the evidentiary portion. I definitely understand the county's position, and of course, the county has the right to appeal.
Thank you.
Thank you.
Thank you.
Have a great day, Chris.
Shauna Baumgartner, case number 2025-372 and 2025-407. Code Officer Cody McGuire, pages 6 and 7 of your agenda.
Good morning. You know how in basketball, there's, 8 seconds to get the ball up court? We're going to start a 30-second clock.
Oh, sorry.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name.
Shauna, it's actually Magaha now. I haven't updated it yet, but
Gotcha. Appreciate that. Good morning.
Good morning. Cody McGuire, Citrus County Code Compliance Officer. Case numbers 2025-00372, accumulation of junk and debris, and case number 2025-00407, unlicensed inoperable vehicles. Address is 8359 North Lazy Trail, Crystal River, zoned RURMH, and it's 1.15 acres. The property owner is Shauna.
Baumgartner.
Well, and Ms. Baumgartner, how do I spell your current last name?
It's MCGAHA.
Magaha.
Yeah.
Okay, great.
Goods service via signed certified mail return receipt and posting at the government building. I'd like to authenticate the following documents and be requested they be admitted in evidence. Photos taken during March 17th, 2025. Corrective action inspection on March 31st. And photos of my final inspection on May 19th. And then Exhibit B is a copy of notice of violation, copy of notice of hearing, copy of the signed certified mail return receipt, and pre-hearing order.
Is that it?
Yeah.
All right. Ms. Magaha, first, I want to ask you, are you contesting whether or not a violation exists on the property?
No, I don't think so. I mean, I agree there was junk accumulated or the inoperable vehicles.
So that's it. There's two cases. One is for the alleged junk, and the other is for the inoperable or junked vehicles.
Correct.
Are you arguing that there's a violation in either of those cases?
No.
Okay. Then what I normally do is I want to ask, how much time is necessary or how much time do you need in order to fix the violation?
I'm not sure how much time is allowed. Maybe if we could do like 60 days. My husband kind of got hit by a truck on the 30th of April.
Kind of.
And yeah, no, he definitely did. And
I
he
see.
died on the 8th. So I've been a little busy
Well, Ms.
lately.
Magaha, I'm sorry to hear that. That's
Thank you.
that would change things a little bit. Did he reside on the property? Do you reside on this property?
Yes.
Okay. Mr. McGuire, can I see the photos? Would you stipulate to these being evidence so I can look and see how much time you need?
Yeah, no, that's fine.
Okay, so you're saying 60 days is sufficient?
It should be, yeah.
Okay, all right. Let me just take a look. Is there anyone from the public who's going to want to be heard on either of these cases? I don't see anybody. How many vehicles are we talking about? That need to be,
Well, I mean,
okay, so I
we've,
see. No, we're not there yet, but I understand.
we've removed 4 vehicles. The
You've
rest,
removed 4.
correct, yeah. The rest of them are actually being worked on that are there so that they are operable. We have like an engine, 2 engines to put into them, and
But is 60 days enough to get all those vehicles either operable or moved off the property? All right,
sorry,
let's,
I don't.
okay,
He
sir, come
owns
on
the
up.
property with me also, so.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Jeffrey Baumgartner.
Okay, sir, 60 days enough?
I would like to think so, but if I could get an extra 30 on that, it would be,
Well, I think on the vehicles, that's usually more than enough.
okay.
You know, so I'm only inclined to do 60 days on that. I'm a little more worried about the junk. I mean, where are we on the junk? Do you think
My junk guy had COVID during this time as well.
COVID?
Yeah, he got COVID and he also has COPD. So
Okay.
I'm trying to get him there as soon as possible. I would like to think I could do it all in 60, but
I mean, that's the part I'm having heartburn about. I feel like that you shouldn't need that much time, but I'm willing to work with y'all on the amount of time for both these cases. Mr. McGuire, is there any reason why you think 60 days is inappropriate, either because it's too much time or that it's too little time?
I think with the progress that they've had now, another 60 days would be appropriate.
Okay, then what I'm gonna do is find that there is a violation in each of the cases, but grant 60 days to bring each of them into violation. Does that make sense? Or into compliance?
Okay,
Does that make sense?
yeah.
What's the county's recommendation on a fine if they don't bring it into compliance as ordered?
$100 per day.
Okay, so what that means is if you get the vehicles done, but not the junk case in 60 days, there'll be a $100 a day fine. Now, if both of them aren't done in 60 days, that's gonna be 100 on each case. So it's,
Okay.
that's the power I have to, you know, compel compliance. It's normally the incentive that it get done within a certain amount of time. Does that all make sense?
Yes.
All right, then that's gonna be my order in each case, 60 days, $100 a day if it's not brought into compliance, and that's gonna be it.
Okay.
Thank
All right.
you.
Thank you.
thank you.
On today's agenda, Aaron A. Cliff, case number 2025-334, Code Officer Cody McGuire, page 15 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Aaron Cliff.
Thank you, sir.
Good morning, sir.
Hello.
All right. So Cody McGuire, Citrus County Code Compliance Officer. This is going to be case number 202500334. Special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. Address is 8624 North Barberry Way, Crystal River, zone CLR 1.15 acres. The property owner is Aaron K. Cliff. Good service via posting the property and at Lecanto Government Building. I'd like to authenticate the following documents and request to be admitted into evidence. Photos taken during initial inspection on March 10th, 2025. Corrective action inspection on April 22nd, 2025. And photos of my final inspection on May 19th, 2025. Exhibit B is a copy notice of violation, copy notice of hearing, copy of the posting affidavit, a photo of the hearing posted on the property and a pre-hearing order. And then,
Well, Mr. McGuire, can you tell me a little bit about what the alleged violation is?
so, yes, sir. Mr. Cliff has his mobile home and like his belongings there on the property. He stated to me that his home was flooded down south and was currently moving up here to rehome. We spoke a few times. I advised him that he needed to get a building permit and stuff like that. That was the first conversation. The second conversation I had with him was whenever I was posting the property, and he was unaware of any of the mail that I had sent.
Okay. All right, then, sir, normally at this point, what I do is I ask you to take a look at the county's proposed exhibits and let me know if you have any legal objections to them being evidence in this hearing.
And Your Honor, I'm being notified that this might be a no contest case as well.
Okay. So, sir, do you
Due to
contest whether?
Special circumstances, me and my son have not received a single piece of mail in 2 months, I think,
Okay,
since we lived there, because Newport Richie decided not to honor our address change.
well, I think what the county is saying is you're not really contesting whether or not there's a violation based on how you have to get a permit in order to use the
Yeah,
property.
I have the permit, but some of the stuff that we need for it was supposed to come in the mail, so. And we still have not received any mail there.
Do you
Probably.
have the permit?
I have the permit book, but
Oh, I see.
I don't have everything that
Gotcha.
requires it.
So you need to get some stuff
I need
in
more time
in
to-
order to pull the permit.
And the power is part of the permit, and Duke Energy wanted 6,000 to 8,000 to clear the easement, and I
Oh, yeah.
can't afford it, so
Oh,
I was
yeah.
doing it myself.
What does, how much time do you need in
2
order?
to 3 months would be more than enough.
Okay, does the county have any objection to that? 2 to 3 months?
No.
Okay, and what's the county's recommendation as to a fine if it's not brought into compliance as ordered?
That would be $100 a day as well.
Is there anyone from the public who wants to be heard on this case? I don't see anybody, so if there's someone out there, just let me know. All right, sir, then what I'm inclined to do is to give you 3 months under the circumstances, and if it's not brought into compliance as ordered, $100 a day.
Thank you.
Okay?
Thank you.
Thank you.
Thank you, Chris.
Next case, Holiday Builders, Inc., case number 2024-1314, Code Officer Cody McGuire, page 26 of your agenda. Expert on the case, Land Development Director Joanna Coutu, and I believe they are not contesting.
Okay, thanks for y'all letting me know.
And I've also been notified we have come to an agreement regarding a one-time fine of $2,500
On this case?
on this case.
Okay, let's,
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Dave Caputo?
Justin Boucher.
I'm sorry.
Justin Boucher.
Thank you.
good morning, sirs. It's my understanding that you're not contesting the violation, that you've come to an agreement with the county. Is that correct?
Yes.
Okay, then what I would do is, first I need to hear from the public. Is there anyone from the public who wants to be heard on this case? I don't see anybody. I'm inclined to honor your agreement and to assume that a factual basis exists, that there was a violation, but just to, from the county's, for the county to agree to that, that's a big thing. Normally they request 5, 10,000, whatever. So if you've agreed on 2,500, I'll honor that, okay?
Yes.
And I'll issue a written order. And that's it. Is there anything else you want to say?
No, sir.
Okay, thank you, sirs.
Thank you.
Dave O'Brien and Jennifer Bishop, case number 2025-201, Code Officer Alan Jonason, page 9 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your name, please?
Patrick Weichel.
Good morning. Your name again?
Patrick Weichel.
Okay. And you're here on the Bishop case? Are you an owner of the property or a tenant?
I close on it tomorrow.
Oh, okay. You're not the owner today, but you're saying you'll be the owner tomorrow?
Correct.
Okay, all right. Well, what's the county's case?
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2025-00201, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102. The address is 6376 North Tamarind Avenue, Hernando, Florida. Property owner is Bishop David L. and O'Brien Jennifer. This property is .28 acres and is zoned CLR MH and was purchased on 1 June 2011. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 24 February 2025, photos from my compliance inspection on 27 March 2025, and photos from my final inspection conducted on 20 May 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the pre-hearing notice, and a copy of the posting affidavit.
So, Mr. Jennison, what's going on the property?
It's a vacant property, and there's RVs and junk and debris and vehicles. There's a lot of material on it.
And your last inspection was done
Yesterday. Yes,
and it's
sir.
all still there?
Absolutely.
Okay. So, sir, here's the issue. I don't know that you as a prospective buyer of the property,
There's squatters, there are literally squatters on the property. I don't know who they are.
right, but have you had contact with the owner of the property?
Yeah, there's dump trailers sitting there right now.
Hold on.
They're living-
So what I'm asking is, you're not the owner of the property. Have you had contact with the owner of the property? And she's selling, or she and he, they're selling the property to you? Where is the closing taking place?
Here tomorrow, and then we're going through with the title company.
That's what I mean. What's the title company or?
I forgot what it's called. It starts with a W. It's in Crystal River.
Okay. I think I know who you're talking about. And I guess my problem is I don't think you have standing to represent the owners. So,
Jennifer, she's incarcerated in a prison in Ocala, and then David's at work. We just found out about this yesterday because none of them stay at that property. It's vacant, like he was saying, with the pictures and everything.
if it's going to close tomorrow and she's in prison, how is it closing?
She's meets some lady at the library to sign papers and everything, and then he meets me at the title company.
Okay. It's like a mail away
Correct.
closing. Okay. All right. Well, I don't think you have standing to represent the owners. So what I'm going to do is I want to see the exhibits so I can issue a ruling. Is there anyone from the public who wants to be heard on this case besides the person at the podium? All right. Thank you. Without objection, what's been proposed as Exhibits A and B are evidence in this case, and I'm going to look through it so I can kind of get an understanding before Mr. Jonason tells me what's going on in detail. And I think it closely comports with everything that's been represented by both sides so far. So please proceed.
On 24 February 2025, I conducted my initial inspection and observed the property to be in violation with numerous vehicles, RVs, and an enormous amount of junk and debris on the property. On 24 February 2025, a notice of violation was issued for special requirements for all accessory structures, which is a violation of the ordinance I mentioned earlier. On 27 March 2025, I conducted my compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 20 May 2025, the property remains in violation. My expert witness is Land Development Director Joanna Coutu.
The first appearance of Ms. Coutu today.
Fortunately, the first of many today, but Coastal Lakes Residential, we know it's vacant. We have no applications as of yesterday for building permits.
Okay, thank you. Mr. Johnson, have you had contact with the alleged squatters on the property?
I have not.
Okay. Do you have any reason to disbelieve anything you heard from the gentleman opposite?
I have no knowledge
Okay.
of any of that.
All right. What's the county's recommendation?
$200 per day along with administrative costs.
Here's what I'm going to do. I want to give you a chance to be heard. So you're a member of the public. Let me know anything that you think I should take into account when ruling on this case.
I mean, if you grant me, like, I don't know, even 48 hours to get them out of there, we can make that happen. Like I said, there's dump trailers there right now. They're loading, so.
I don't have any jurisdiction over you, so it's not a matter of granting you anything. I think that what I'm going to do is issue an order finding that there is a violation and allowing a certain amount of time. It is going to be more than 48 hours to bring it into compliance before a fine begins. But the logistics of does this, if it's not brought into compliance, is this order going to be an encumbrance on the property? Will it ultimately transfer to a new owner? I encourage you to seek legal counsel to figure out what the potential consequences of this are if it's not brought into compliance. Okay? All right, so I find that the property is in violation. I will grant 10 days to bring it into compliance. If it's not brought into compliance in 10 days, a fine of $200 a day will accrue.
Thank you.
Thank you. Thank you, sir.
Thank you.
Next case is Rebecca C. Marsh, case number 2025-374 and 2025-438. Code Officer Cody McGuire, pages 30 and 31 of your agenda. And they are not contesting.
Okay. These are two cases?
Yes, sir.
Same property. All right. Good morning.
Good morning. Yes. I do. Rebecca Marsh.
Good morning, Ms. Marsh. So it seems that you're here regarding a property located at 3214 North Quarter Horse Terrace,
Yes. That's my home.
and you're not contesting whether or not there's you're not contesting that there's a violation, both pursuant to the quote-unquote junk case, as well as the, I call it the inoperable vehicle case.
That is correct.
Okay. And how much time do you need to abate these violations?
If I could have 2 weeks more, I would appreciate it.
Okay. All I like to do is I like to look at the photos to see, so I don't want to set you up for failure. In other words, if it's, we have a junk scale. I have a junk scale. So on a scale of 0 to 10 on a junk case, 0 being it's perfect, why did the county bring the case? A 1 being there's a rake in the wrong place on the front yard. A 10 being it's Sodom and Gomorrah out there. A 10, 14 days probably isn't enough. All right, so let me just take a look. Oh, I definitely think that's enough time. This is, what do you rate this on the scale, Mr. McGuire?
Man, it's only dabbling on it. It's not much.
It's not a
Yeah.
1.
If
I
it
mean,
has to read, it's a
it's
1.
close, but all right.
Can we go a half?
Okay, what's the county's recommendation on these cases?
The county would be $100 per violation.
Ma'am, I am inclined to grant your request of 15 days to abate the violation in each case. And if it's not brought into compliance as ordered, it'd be $100 a day.
Okay, thank you.
Okay, let me just add, I don't know if I asked for the public input. Is there anyone from the public who wants to be heard? All right, I didn't hear anybody, so thank you.
Next case, Michael J. Stites, case number 2025-244. Code Officer Alan Jonason, page 42 of your agenda. Expert on the case, Land Development Director Joanna Katu.
Morning.
Good morning.
I do. Michael Stites.
Didn't want to violate the shot clock there.
It's close. I mean, but as you know, with the refs these days, it's not always called very quickly, so please proceed.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2025-00244, Citrus County Land Development Code, Section 4002, site development without a development order or permit. Address of the violation is 10615 North Big Bass Trail, Dunellen, Florida. Property owner is Stites Michael J. This property is 1.14 acres and is zoned CLMH and was purchased on 7 April 2023. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 25 February 2025, and an aerial photo from the property appraiser's website from 6 May 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, and a copy of the pre-hearing order.
Can you tell me a preview of what is factually being alleged?
Yes, tree removal and site grading on the property.
Okay. Now, before we get into this then, sir, are you contesting whether or not there's a violation?
No, I've actually met with Alan. He's been very professional and kind. I met with Lori actually too. I wanted to save the court some time and everybody here. I don't want to waste any further resources. No, I'm not contesting that a violation occurred. I was just going to kind of maybe say a couple words to maybe mitigate.
I want you to have that opportunity, and
I'm not contesting.
the fact that you made it here despite actually meeting Ms. Spiros, who normally brings the crowbar. I mean, good for you. You made
Maybe
it.
I got lucky.
You were persuasive with her, but I'm happy to hear whatever you have to say.
May I?
Yeah, you're not contesting there's a violation, so go ahead.
So, yeah, just a little context. I had bought the property a couple years ago. I'm from Longwood, just north of Orlando. My wife and my in-laws have lived here for over 40 years in the Crystal River area. We're very aware, because my father-in-law talks about it all the time, people coming into town, buying property and just clear cutting the property. That is not what's happening here. In fact, I have a neighbor, which I discussed with Alan, that when I bought the property, I noticed it looked like a Walmart parking lot. It actually made me kind of sad. When I bought the property, I wanted to preserve the very essence of the property. So when I went out there after the last few rounds of hurricanes, it was completely flooded. I guess all my neighbors, over time, and I don't blame them, channeled their runoff into my yard. So there was just a mat of mosquitoes. There were broken branches up in the pine trees. I have a little 18-month-old son that I wanted to bring out. One of my friends was like, well, you really should get a tree guy out here just to take a look at it to make it safe. Long story short, it was supposed to be just removal of dead trees, rotting trees, damaged trees. And I had a gentleman also come in and say I could just put in some dirt to get rid of the resting water. I was actually doing it to improve but not take away from the land. Long story short, I hired local. I thought I'd hire local, license each company. I think it's All Around Tractor LLC and Griffin's Tree Services have both been around for over 20 years. They did great work. Problem is, I live in Longwood. They started doing the work. I get a notice in the mail and it said, you're in violation, no building permit. Well, that's news to me. I felt horrible. I, in fact, took off work the same day, drove out. That's where I met Lori. Drove back out a few days, took a second day off of work, spoke with Alan. I am taking this very seriously, and I was pretty frustrated with the gentleman that I hired because they said, well, we didn't know about a permit. I'm like, I'm looking at it right here. I kind of trusted you. Long story short.
Did they report you?
I had a neighbor that I guess didn't like that he heard noise because he had been used to no noise for 40 years. So he called, and lo and behold, no permit. So that was news to me as well. Long story short, I didn't mean to do anything. I am very remorseful. They did remove some trees, and I was just asking for the county and Your Honor to consider some mitigating circumstances when levying a fine. I know that I owe you guys something, and I'm hoping it's just not too much.
Have they had discussions with you about what the fine amount could be?
I'm reading it here that it's up to 15, and that would do some significant damage on me. I'm hoping if it can be under 4, I could try to pull some money
What's the
together.
county's recommendation?
5,000.
Okay. And that's consistent with county policy. And is there anyone from the public who wants to be heard on this case? All right, then I have to solicit public input as well on each case. Sir, if you wouldn't mind coming forward, we have to go through the procedures here. And I'd ask that you come up where Mr. Jonason is. Over there, if you would.
Kevin McDonough.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Your name, please?
Kevin McDonough.
Thank you.
Thank you, sir.
I just want to say I'm a second-generation arborist, been doing it my whole life. In different situations and commercial applications where replanting is available as an option, opposed to fining per caliper inch. In a lot of cases, we've had to work with the city of Orlando. I haven't had an opportunity yet to do it with Crystal River, but we do a lot of replanting of new plants to mitigate the fines. And if maybe you guys could set a plan up for him to install new trees per caliper inch to make up for what was lost, because
Well, first of all, if you want to talk to Crystal River, you should talk to Mr. Hartley in the back of the room, but I'm just the special master for Citrus County, and I'm sympathetic to what you have to say.
Okay.
My authority is limited by the words in this
I understand that.
binder,
Law's
but
the
I
law.
appreciate your input.
I just wanted to say that.
I
Thank you.
think a lot of people agree.
I actually plan on putting more trees, like, the goal is to put trees in.
To be a proper steward of the property and of the Florida native land. And so we have the county's recommendation. What I'm going to do is I'll do a fine of $3,000 in lieu of the mitigating circumstances, the request, and I think a persuasive proposal.
Thank
So,
you.
Thank you.
Thank you.
Thank you,
Thank
Mr.
you, Your Honor.
Stites.
Thank you, Alex. Thank you. Thank you, Lord.
Next case, Francis C. Bass, case number 2025-130, Code Officer Cody McGuire, page 5 of your agenda.
Yes, ma'am. Patricia Riggles.
I'm sorry, what's your name, ma'am?
Patricia Riggles.
Riggles? And this is on the Bass case?
Yes, sir.
Are you a tenant of the property?
No, Frances Bass was actually my mother, and she passed away.
Got it.
In 2021.
All right, so you're an heir and
Yes.
conceivably the owner
Yes,
of
sir.
the property. All right, please proceed, Mr. McGuire.
Cody McGuire, Citrus County Code Compliance Officer, case number 202500130, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 6959 West Arter Street, Crystal River, Zone MDRMH, and it's half an acre. The property owner is Francis C. Bass. Good service via posting the property and at the Lecanto Government Building. I'd like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during initial inspection on March 19th, corrective action inspection on April 3rd, and my final inspection on May 19th. Exhibit B is a copy notice of violation, copy notice of hearing, copy of the posting affidavit, a photo of the notice of hearing posted on the property, and a pre-hearing order.
Okay, ma'am, are you contesting whether or not there's a violation
No,
on the
sir.
property? All right. How much time do you need to abate the violation?
Probably a couple months at the most.
right.
We're working on it now.
All right, I'd like to see the photos if possible. I don't know if that's my good angle. All right. Thanks. All right, we'll admit the photos as evidence. I'm just looking at it so I can look and see how much time I think it would take to abate the violation. Has there been improvement since you opened the case, Mr. McGuire?
Yes, sir, there's been a lot of improvement.
Okay, what's the county's recommendation?
That would be $150 a day.
Is there anyone from the public who wants to be heard on this case? So, ma'am, I think 60 days would be fair, a couple months. I don't think this is an overnight thing. It looks like multiple trips to the dump, that kind of thing.
Yes, sir.
If it's not brought in compliance as ordered, it would be 100?
Yes, sir.
100 or
$150.
$150 a day. All right, thank you, ma'am.
Thank you.
That's the order.
Thank you.
Next case, Cheryl J. Rutledge, case number 2025-419, Code Officer Cody McGuire, page 31 of your agenda.
I do. Karen Wilson.
Good morning, Ms. Wilson. Are you an owner or tenant of the property? Or?
I am not. I do have recent, as of the 16th of this month, power of attorney
Okay,
for the owner.
I see. So you are in possession of a power of attorney for Ms. Rutledge?
Yes.
And do you have a copy of that power of
I
attorney?
do.
Okay. Let's, if we could, take that up first. I want the county to be satisfied that you can stand in her shoes and represent the property owner. And I'll take a look at that after the county. Mr. Trellin, this is a real upgrade on production value. Okay. Are you checking the witnesses, the notarization, the? Okay. Okay. I see. Let me just take a look. Is this your only copy, or is this a copy that we can keep?
That's a copy you can keep.
Very good. All right. It's okay, so this is a comprehensive, durable power of attorney, correct?
Yes, sir.
Okay. Is there any objection from the county as to Ms. Wilson's standing? No. All right, please proceed.
Okay. Let's see. On March 20th, 2025, I conducted an initial inspection and Initial inspection of the property and observed the violation. The notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed above. This consisted of household garbage, items, bicycle parts, construction materials, and other debris. On April 3rd, I conducted a corrective action inspection and observed the property remaining in violation. I have had contact with Ms. Rutledge. She explained to me that she was trying to get a hold of the property manager to get over there and take care of the violation, and that she was unable to make it today. And as of my final inspection on May 19th of 2025, the property remained in violation.
Ms. Wilson, are you contesting whether or not there's a violation on the property?
No, Your Honor, I'm not contesting. What I do need is a little bit of clarification. I did go to the property and took some pictures myself. It appears that I was advised that the people that were living there were moving out, but it appears now that we have squatters. And so trying to remedy the situation is a little bit more difficult than I anticipated.
Well, of course, I always encourage property owners in this situation to seek legal counsel as to what their rights are, whether it's regarding the lease or despite squatters or tenants being on the property, what rights the owner has to go and clean it up. I often hear that, we're powerless to go on the property, clean things up. And I think that's determined based on the terms of the lease and also Chapter 83 Florida statute. So I encourage that. But it sounds like you're not contesting that the violation exists, just that there is an impediment, perhaps, to cleaning it up.
Yeah, our intent is to do an eviction. and
Or
move forward
if it's
from there.
squatters and perhaps an unlawful detainer or ejectment, or, okay, I'm not your lawyer, please seek legal advice. And let's see, what's the county's recommendation on this case?
$100 a day.
How much time do you think you need to start that process? I mean, keep in mind, you might be able to handle that process quickly in the court system. But again, I encourage you to seek counsel on that. How much time do you think you need?
I would ask for 60 days so that if we do have to do an eviction, we have some time to get that process going.
Okay, can I see the photos? I haven't had coffee this morning. Is there anyone from the public who wants to be heard on this case? Don't know if I asked. I don't see anybody. All right, let me take a look. You'd hope these are squatters and not someone willfully doing this to their own property. All right, I'm inclined to grant the 60 days to abate it, and if it's not brought into compliance as ordered, $100 a day.
Very good.
All right, thank you.
Thank you.
Thank you.
Next case, WJHFL LLC, case number 2025-360. Code Officer Julie Wilkinson, page 47 of your agenda. Land Development Director Joanna Coutu, expert on the case.
I do. My name is Robert Christensen.
Good morning, sir.
Good morning, sir. How are you?
Good, how are you?
Doing well, thank you.
Good morning.
Good morning.
Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 2500360, a violation of Citrus County Land Development Code Section 4002, site development without a development order or permit. The address is 10246 North Sherman Drive, Citrus Springs. Property owner is WJHFL LLC. We have good service via posting the notice of violation at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they'd be admitted into evidence. Exhibit A, photos I took during my initial inspection on March 13th, 2025. Photos from a corrective action inspection on March 28th, 2025. Photos from my final inspection on May 19th, 2025, and an aerial from the Citrus PA dated May 6th, 2024.
Can you proffer a narrative about what's happened on the property?
So it's a vacant lot, and it was cleared of all the trees, graded, dirt was brought in, and that was also graded out. There's been no permit that was issued. There was a permit that was applied for on April 25th, 2025, but it's not issued yet at this point.
Okay. All right, so sir, before we get into the exhibits and everything, I guess I just want to know from you, are you contesting whether or not there's a violation on this property?
No, sir, we're not contesting.
Okay. Well, then I think the question is this the kind of thing that can be remedied, or what is the county seeking?
The county is seeking a one-time fine of $5,000.
Okay. I mean, is there, sir, let me ask you some questions if I could.
Yes, sir.
I mean, what happened? Are y'all seeking a site development plan or permit, or what's going on?
So, yes, sir, just to give you a little background, I'm here on behalf of the company today. My position is a construction manager, so generally I receive projects once the permits have been completed and processed through the county, and then to go on and proceed with construction. However, my understanding is that this lot, we purchased this lot, and then there was an administrative error on a spreadsheet that is used for lots that are released to the grading company for clearing. So it's my understanding that that's what happened and why this lot was cleared. So I am told by management that there are additional business practices that are being implemented to help mitigate this from becoming an issue again in the future. But we do have we have applied for a permit with the county, and based off information I've received from our permitting technician, it was sent back from plans review for a few final documents before it will be released for construction.
Okay, I think that's consistent. Ms. Katu, is there anything you wanted to offer?
Actually, the permit's ready to issue on May 16th. They just need a mechanical contractor, and we can go ahead and issue it. So they're very, very close.
Okay, all right. Is there anything else y'all want to say?
May I just speak on the mechanical contractor? So we, as a company, have recently made a change on the mechanical companies that we're using. So we're just waiting to get everything finalized with that new company that we're transitioning to. So I believe that may be why that information has not been presented to the county yet.
I don't, in terms of not going to finish and pick up a permit, I've seen much, much worse. I mean, I don't think this is a crisis. Did I already ask, is there anyone from the public who wants to be heard on this case? All right, I don't see anybody. In this kind of a case, I do issue a fine because of the deterrent value and that sort of thing. In other words, it's difficult to distinguish between a property that is cleared by administrative error and a property that's not. I have no reason to disbelieve your testimony, by the way. But I am going to assess the county's requested fine of $5,000, and that's it. That's all I'm going to do. Okay? Thank you. Yeah.
Would you like the evidence?
I don't.
Okay.
It was not contested.
Thank you.
All right.
Thank you.
Thank you, sir.
Next case on the agenda, James Ware, case number 25039, Code Officer Cody McGuire, page 45 of your agenda.
This is my case.
I
do.
James Ware.
Good morning, sir.
I have something I'd like to present to you, if that's okay.
Well, can you represent what it is?
It's just a short explanation of the whole situation, so it makes it very simple.
We can get
With a
into
couple of
that.
photos.
Not quite yet,
Okay.
if you don't mind. First of all, I guess maybe it would help. Are you contesting whether there's a violation?
I don't believe there's a violation.
Okay.
It's very vague, so I just would like to see what.
That's fair. That's fair. So what I do before hearing your version of the story is I don't even know what you'd be responding to without hearing from the county
Sure.
first. So please proceed.
Erica Olson, Citrus County Code Compliance Officer. This is case number CE 2025-00309, a violation of Citrus County Land Development Code, Section 4002, site development without a site development order or permit. The address is 6023 South Mason Creek Road, Homosassa. This lot is 7.31 acres and zoned CLR. Property owner is James Ware. I have good service via signed certified mail return receipt and posting at the Lecanto Government Building.
Can you offer a narrative of what the case against Mr. Ware is?
So he has brought in a bunch of fill dirt and removed some trees from a vacant parcel.
Okay. And so this is under section 4002A. No development allowed by this code shall be established, changed, or altered, et cetera, et cetera. Well, I mean, is there, okay, so it's subsection A that you're proceeding under. Is that a yes?
Yes.
Okay. All right, now I would like to hear, before we get into the exhibits, can you show it to the county? They need to look at that. Let me know if they have objections to it before I get into it. Is this just something?
Copies if somebody else.
Is this just something you want to read into the record? As well? I mean, you want to introduce it, but also read it?
If you'd like for me to, I can.
I don't know. Let's have the county take a look at it.
I think it's easier for you just to take a look at it and make a determination.
Probably would be, but we don't always do things the easy way.
I removed no trees, by the way.
Okay.
Should I give them the pictures, a couple of the pictures too?
We'll get to that because you will have an opportunity to lay whatever evidentiary record you want.
Thank you.
Does the county object to me receiving this for any reason? No? Okay. Then I will just take a look at it real quick, and then I still need to let the county deal with its exhibits, but let me just review it real quick. My concern is that this might be a motion to dismiss of some kind.
Do I have any exhibits they have I can review? I was asking for them. They said
Yeah,
I could
hey,
only see
sure.
them at the.
While I'm reading this, can you review what the county has, and then let me know if you have any
Sure.
objections?
Thank you.
This is just the paperwork that's sent to you.
Okay, got that.
You know that, and then you got it all pre-hearing.
I've got that, yeah.
Okay. These are just photos that I have taken. Right?
Okay.
My inspections are all date.
Want to see mine?
Not yet. So, Ms. Ware, do you have any objections to what the county has shown you?
No.
Okay, then we'll admit those as exhibits A and B. And I'm going to, do you swear or affirm that everything represented on this paper that you've submitted is true to the best of your knowledge? Okay, then I'm going to admit that as exhibit C. Okay. I'll allow the county to proceed with its case.
Okay, sorry, those photos are just now out of order.
That's okay.
Okay.
And actually, I'll want to see A and B. That's okay. Thank you.
Can you see these two there?
Not quite yet,
Okay.
sir. Believe me, I will let you know. I promise. You'll get your chance.
Thank you. You're very
Okay.
pretty.
Go ahead.
Continue. On the 3rd of March 2025, I conducted my initial inspection and observed that fill dirt was brought in and the site was graded. During this inspection, I observed a dump truck dumping a truckload of dirt. An NOV was issued. On the 18th of March 2025, I conducted my corrective action inspection and observed fresh tracks for machinery and the fill dirt remained. I also reconfirmed that no permits had been applied for and an NOH was issued. On the 1st of April 2025, I conducted a subsequent inspection because I received a call from road maintenance inquiring about my case because the road was flooded from a heavy rain we'd had the day before. The growth management director also went out to the site due to calls that he received regarding the property. I spoke to the property owner and he requested that I meet him out to discuss his case. On the 2nd of April 2025, I met with the property owner at the above address along with the growth management director, the code compliance director, road maintenance, and technical services. This meeting seemed productive and the violation was explained by several of us there to the homeowner. On the 19th of May, I conducted my final inspection. The dirt does seem to remain and it does appear that grass was planted.
So just to be clear, the county isn't presenting a case for the fallen trees, just the fill dirt?
Well, we do believe that the trees were removed. He says that they weren't, but I think the biggest thing is that the fill dirt was
I just want to make sure I understand
I
everything the
understand.
county is proceeding under. So the county is saying that the quote-unquote tree removal is a violation of the code. In addition to that, the bringing in and placement of fill dirt is a violation of the code.
Yes, sir.
And is there anything else?
No, sir.
All right. So I think we're on the same, actually, Ms. Katu, is there anything you want to offer at this point? Okay. So Mr. Ware, I definitely, first I want to ask you about the dirt, because I think in your document that you provided and sworn, you're not arguing the fact that you actually have brought in dirt. What you're saying is this is to fix a problem created by hurricanes and erosion, and in any event to improve the property, correct?
Correct.
Okay.
Just to actually restore it to prevent from fire. You know, when I was there after the two hurricanes we had, the fallen trees are all over it and the dead debris. The corner was used as a dump site by the county. They instructed everybody to put it on the right-of-way, so everybody chose to put it on my right-of-way. So when they finally cleaned it up in January, when it was finally removed, that's when I went in and started cleaning up the property. When I cleaned it up, I took out all the dead trees. I put in some topsoil to cover the root systems and the holes that were produced by the trees that had fallen over. And then I planted it with grass. And what you can see here, the water she's talking about on the road, way that the corner is done, there's one tree that's there that's actually on the 6-foot easement that really needs to be removed, but I was able to go in and grade it and take care of it to where there's no water on the road, but, and I can have a picture to show you that as well.
I want you, if you
know,
want to
when
try.
I was out there that day, they showed me that. Before they got out there, I'd already dealt with that problem. When I saw that, when we first had a rain, we were in a dry spell for 2 months. We had a rain. I saw it. I went and took care of it right away. I mean, this is just a pretty piece of property. I'm just trying to make it.
It is a pretty
acceptable.
piece of property. All right, so let's go one
And
at a
making it
time.
where
Let's go one at
people
a
aren't-
time.
Mhm.
So first, is there any cross-examination you want to have of Ms. Olson?
Well, when I was there on the property, we discussed it, and they said that I did not remove any trees. That's the way they had seen the property. The lady over here as well had gone through the whole property and said she had already looked at it and said I didn't bother the wetlands, I didn't do anything that she saw that was bad. When they looked at the dirt, you know, they determined with me there's really no way to remove it. If I go remove it now, all I do is kill the trees, because all I did was cover the roots of the trees. You know, and all I did was
My
plant
question was a
grass.
little more simple. Do you have any cross-examination that you want of Ms. Olson at this time?
No.
Okay. And about these photos, I want to give you an opportunity to introduce them. Is this your only copy, or do you have multiple copies?
That's okay, you can have
Okay.
this.
Can you show them to the county? And
This is the
can,
picture after the heavy rain we had the other day.
well, no. Hold on. Let's just show them to the county first, and I want to know if the county has objections to them. And then if you speak into the microphone, let them have the photos, sir. Let them have the photos. Go to the microphone if you would, and tell us what these are photos of. Into the mic.
The one photo is just recently we had 2 inches of rain overnight. And so if you see on the corner of the property, across my corner, on the other corner, it floods the entire road out. Where I did, I have nothing, no issues whatsoever. I took care of any issues, but the road still floods, but it's on the other corner of the property. I clean the area so when the people come up to the road, they can see the traffic coming, so it's not a hazard anymore. There's always been accidents there in the past. All I did was help in the neighborhood. In front of there is where all put their signs. I planted zoysia in front of it, and I plan on making it just a pretty entrance when people go into Hancock. I have no desire to do anything with the property other than what I've already done. So whatever y'all want to do to me now, do it, and we'll go past that.
All right. Does the county have objections to the photos that have been proposed by Mr. Ware as evidence?
I have some questions.
Sure.
Mr. Ware, did you take these photos?
Yes.
When
No,
did you
Mr.
take-
Ware, actually, if you don't mind, it may become necessary,
hard
but
for
we'll
me
get
to-
into that.
My
When,
vision,
when did you take these photos?
after this rain we had just a few days ago, maybe a week ago or something like that. We had a heavy rain overnight, last week.
I'm fine
sometime.
with that answer.
It did.
That's it. That's good.
I'm looking at a photo that has,
All that water standing
Sir,
is
can I
across
finish?
the corner from me, it's not my.
Sir,
corner.
wait for the
Okay,
question,
sorry.
if you would.
I'm looking at the photo, it has 2 dead-end signs and 2 street signs, one right in the middle and one towards the left, and what looks like a big group of directional signs over here on the right-hand side of the photo. Where in this photo, the left, the right, or the center is your property?
You see those signs up there?
Which, there's
On the
3
left.
sets of signs.
The,
One's on the
straight up
left?
in the top left corner of the
Yeah.
piece,
This
right
one
up
over
there,
here?
those signs, that's my property.
So this right,
Where-
this corner
not-
right here?
No, that corner there is where all the water's, the corner by the signs is the property,
Back here?
yes.
So the middle of the photo.
Well, it's 7 acres, so it's that whole thing, yes, ma'am.
Okay, thank you. On this photograph that has no signs on it, is
Mhm.
this all your property?
Yes,
I'm looking at this photo that just has one street sign and it looks like a T with a dead end. The right, left, or center, which
the left
property is
is my
yours?
property,
This corner right
Yes.
here on the left,
Mhm.
okay. And do these photos fairly and accurately depict the condition of the property at the time that you took the photo?
yes.
I have no questions.
All right. Do you have any objection to them being evidence? Okay, so we'll introduce them, thank you, as Exhibit D. Okay, so you've got the evidence in, and I'm just going to take a quick look at it. I've looked at it. Is there anything else you want to let me know at this point?
No.
Okay. Does the county have any evidence that shows the trees were removed not, as by any other means than what he described?
No, we do not.
Okay. Then as to that alleged violation, I'm dismissing it. I don't find a violation of tree removal. I find that the respondent's testimony is credible, and it's affected a lot of properties that way. As to the fill dirt, I think that, whether you have good intentions or not, I think it's the county's position that you have to obtain proper permitting or plan. What is the county's position on that? What do you need? You heard what he said. He brought in dirt to remedy a problem on the property. What would he have to do in order to do that, to satisfy the county?
He would have to obtain a permit, however, you want to speak on this? Yeah.
So generally on vacant property, you cannot get a fill permit. If you can talk about, there's a I saw some stuff about related to the roadway, et cetera. You can work with road maintenance and there might be some ability to do something out there to alleviate the reason he needs fill. Otherwise, a primary structure permit would need to be established to go in there and level this out and make it clear.
Okay, so the reason that on a piece of vacant property, you can't just get a permit to put in fill dirt is because it needs to be connected to something else.
To a principal structure,
A principal
yes.
structure. And what about the event where an act of God occurs and maybe it creates liabilities on the property? What if it creates divots or ponds or something that kids could fall into or something like
And
that?
we can certainly look at that on a case-by-case basis. We don't know anything about that. That wasn't brought to us. So in this case, it's hard to do it after, so I don't know.
All right, I understand. Is there anyone from the public who wants to be heard on this case? What's the county want to do?
We want to do a one-time fine of $5,000.
I do find the explanation that's been provided to be earnest and persuasive. I don't have any evidence to the contrary. At the same time, I do agree that a permit is necessary, unfortunately. So based on the mitigating evidence, I'm going to assess a fine of $1,500. It's the lowest fine I think I've ever issued for this kind of a case, but I think that is the law, so.
Thank you.
All right, thank you.
Thank you, Your Honor. Where
Next
do I pay
case.
that at?
Well, I'll issue a written order, but please stay in touch with the county.
Next case, Kevin McDonough and Crissander Marcus, case number 22-6, Code Officer Cody McGuire. Page 32 of your agenda, expert on the case, Joanna Katu.
You brought the heir to the property?
Yes.
Okay.
All right. Raise your hand.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes, ma'am. And your name, please? Cassandra Janelle Marcus. Thank you.
Okay. Good morning again, and good morning.
Good morning.
Ready?
Yep.
All right. Cody McGuire, Citrus County Code Compliance Officer, case number 202500226. Special requirements for all accessory structures, 3102E. Address is 5149 West Amon Street, Denellen, Florida. It's 5.35 acres in a zone TCU. Property owner is Kevin McDowell and Cassandra Marcus. Good service via posting the property in at the Lecanto Government Building. And I'd like to authenticate the following documents and request that it be admitted into evidence. Exhibit A, photos taken during initial inspection on February 13th, 2025. Photos during a corrective action inspection on April 24th, 2025, and my final inspection on May 19th of 2025. And Exhibit B is a copy of notice of violation, copy of notice of hearing, copy of the posting affidavit, and a photo of the notice of hearing posted on the property and a pre-hearing order.
Okay. Sir and ma'am, normally what I do before I have you look at the exhibits is I just want to know, are you contesting whether there's a violation on the property? And it's okay if you are.
On one of them we are, and one of them we're not.
Oh, we have two cases?
I don't know.
Just the Connex.
Just the Connex, and the other one already got taken care of.
So you are contesting that the Connex is a violation?
Correct.
Okay. Then why don't you take a look at the exhibits that have been offered by the county and let me know if you have objections to them being evidence. This thing where we can constantly look at ourselves, this is trouble. This is trouble. It's a... Huh? Well, I mean, it is big time, but it's the modern echo chamber that we all get into a little bit, and it's dangerous for society, if you ask me. My daughter got an animal that just repeats everything she says back to her, and she can talk for hours to herself, you know? So that animal has sadly met an untimely demise. Right. Y'all, do you have any objection to these documents being exhibits?
No, sir.
Okay, all right. Then without objection, they will be admitted as exhibits A and B. Got it. And Mr. McGuire, I'll just take a moment to look at this before you continue.
Mm-hmm.
How big is this property?
5.35 acres.
Okay. All right, please proceed, Mr. McGuire.
Okay. On February 13th, I conducted an initial inspection and observed the property to have container on the vacant land. On April 24th, a corrective action inspection was conducted with no change. I've had contact with the property owners since they've come in contact with the violations. And on my final inspection on May 19th of 2025, the property remained in violation. The conversations that I had, they've had a lot of unfortunate problems happen with them as well. But when they did come in with the notice, they have been trying to come in.
Well, Mr. McGuire, in plain terms, what's the violation?
There's a Connex on vacant land.
Okay. And that's why it's brought under 3102E. What would they have to do in order to have that legally?
I'd like to refer this to Joanna Katu.
Please.
You can't have a connex legally on residential land. That's been removed from our land development code. So if there's a house under construction, of course, as construction material, they had a mobile home permit, not a house, but a mobile home permit that has since expired. So like, there's no way to permit that connex.
Let me walk through that piece by piece. So if they did have a permit for the mobile home, even if it hadn't expired, let's say they got it reissued or something like that, they would not be able to have the connex.
Right, those are not allowed as storage structures on residential lots.
And was that originally something that was allowed?
It was years ago, and we've tackled that one, yeah.
Okay. And why was it removed?
A lot of complaints. People were using them, and they're not particularly aesthetic. I
Okay.
assume that's why.
So it's the county's position that no matter what happens with any permit, that will not be allowed to be on the
The
property.
connex, I mean, you can use the bones of it and dress it up, but yeah, the connex itself cannot be used for residential storage.
Why is that not different from, or why is it different than, say, a ship? I mean, is it different than a shipping?
It's not. Shipping containers are the same. The connex shipping containers and also trailers. You can't bring in one of those semi-trailers for storage. They're all lumped in the same.
But I think
Yeah, it's I think the accessory structure, but it might be one specifically for storage. I know you use your book a lot. The book is not as up-to-date. The online is going to be the up-to-date LDC, so did want to caution you on that.
Well, here's what I'll just tell you what I'm reading. So, and it's in the agenda as well. 3102, all accessory uses, regardless of location, shall be allowed once a permit is issued and meets the following requirements. It shouldn't read this way, but it is the way it's written. And then E, vehicles, trailers, manufactured housing, shipping containers, and similar units and mobile homes shall not be used as a storage building, utility building, or other such uses. So I think it's, what you're saying is that this section here, I mean, I guess I'm having trouble reading this section because the way it reads to me is that shipping containers can be used once a permit's issued.
No.
That's not the way.
Right. E basically says all of those types cannot be used as storage.
Oh, actually, you're correct, because it says that all accessory uses will be allowed, and as long as it meets those requirements, and then it puts E in there. So a permit issue has to follow that requirement, correct? That it not be allowed.
It cannot be. You cannot apply for a permit for these uses for storage.
That's a difficult read, in my opinion, but I accept what the county's saying. So let me turn to the respondents. What is y'all's position for why this is allowed?
Okay. First off, I would like to say, my son, we just found out about the permit recently. We're going tomorrow to reapply.
That it expired, you just found out.
Yeah, the home permit, as soon as I leave here today, I'm calling the modular home company. That'll be redone, because it was originally a 2024. Now it's gonna be a permit for a 2026 modular home. You already have everything rocking and rolling, so our home should be out there within the next 90 days. The modular should be out there. So what is in that connex at the moment is my whole family has passed away. So that is my whole life. That's all my furniture. It's all my kids' stuff. It is everything. Recently, my baby ended up in Shands Hospital from salmonella and meningitis in the brain. So when that happened, we put everything on hold because our baby's life was at stake. He had a 30% survival rate, and he literally almost died. So he literally just got discharged, and it's been ongoing battle with him. So now that is, now he's better, we are back on the roll getting this done. So we were hoping with the Connex, because it has some building materials in it for going towards the modular, and it has all the furniture, my whole family's life. I mean, I have everything in that, like that Connex, really, like everything. If there is any type of way, when we can either get an extension for it, it would be gladly, really, really appreciated, and then we will have that Connex out of there. We just need some time for that. And then I had also reached out about getting a permit for a storage container. And then, like they said, that you can't have a permit for a Connex. I did find that one out yesterday too when I spoke with Tiffany from the building division. But my main thing is I have all these documents to give to you to show why stuff was put on hold. And I also have stuff with the home as well, all that and set.
Whatever you want to admit, I encourage you to give to the county. And they'll let me know if they have objections to it, but you have the right to lay your record.
Okay, I have that, and then whatever Kevin wants to say, but if there's any possible way that you could just give us an extension on that Connex, just until our house is out there, it should be within 90 days, it should be out there, and then we get rid of the Connex.
I will tell you, I mean, I am gonna find that it's a violation. I can't give an extension. What I can do is a time to comply, right? So we'll talk about that, but if you would, please share your documents with the county.
At this time, I'd like to address the situation of the Connex on the property. When I first applied for the permit, I was ready to go, gung-ho. This is my first time building a house. I went down to the county, I applied for everything. I went back there a couple times and did a few things that I missed. I have no problem doing everything step by step that what the county wants to do. Our permit has just expired as of yesterday, I believe, or the day before. So I'm gonna be back down there again, reapplying for the home permit. Is what I would like to do is modify my site plan and an 8x40 storage, not a storage, but an 8x40 building, and I will put siding on it and just use the structure.
You want to convert it?
I want to convert it and just use the structure and make it visually appealing. The complainant in this case that originally turned the county onto me, he is totally happy with my property. He said he retracts the statement. He doesn't want to pursue any more complaints. And
if only you could travel back in time.
yeah,
man.
so I understand the ball's rolling, but I'm willing to modify the structure to make it visually appealing to the county.
Your
to
only problem with that
whatever
is that if
standards
you
they
do
want.
end up wanting to modify your plan, you know, that's going to extend the time that it takes to get everything approved, probably. You know, because in other words, you already
Well,
had a permit for what you wanted to do.
The lady from the county said that you can use the structure of the Connex, but you have to modify it. You
Well, I
can
know
use
what
the
you can do.
skeleton
I agree with
of
you.
it.
But
Yes,
what
sir.
I'm saying is, it may be that the process for getting plans in to do that, to get it approved, and you've heard today, sometimes things go back and forth and they take time. There's no
Yeah.
guarantee that it takes
Right.
15 days, 30 days, 60 days.
So
what I'm trying to say is that it may extend the amount of time you actually need to before the violation begins to accrue.
Okay, I'm thinking within 120 days, our house will be there, finished, and furniture moved in, and all our family belongings will be safe inside the new house.
Is there anyone from the public who does want to be heard on this case? I don't know if the complainant's here. Okay, I was just curious.
Okay, yeah, so the complainant, my other neighbor has a Connex, like right next to me. You drive through my neighborhood, all through, what's the name of it?
Almond Street and Buchanan.
No, what's the name of the neighborhood?
Mini
Mini Farms. There's 50 Connexes in Mini Farms. So if we're gonna hold me to the law,
You know,
I don't want
if I had a
50 people
nickel
to
for
have to
every
remove their
time
I
someone
just
said,
wanna be able to
yeah, but my neighbor or someone
put
across the
siding
street
on my
also,
comments.
I just have the case in front of
Yeah,
me.
I understand.
Ms. Harrison?
I actually have a few questions Thank you, Ms. Katu. I actually have a few questions. The first thing I'm looking at is it looks like the contract for purchasing your current residence. Okay, is this the only one you have? Is this the only copy of these documents that you have?
Yes, that's the only one we
Those are
have.
the ones I have paper. There's other stuff that's in email.
I just want to know if these are the only ones you have.
No, I have stuff in email too, like, that has the spec sheet, the whole 9 yards.
Well, I think and Ms. Harrison, let me know if I'm wrong, but one of my concerns that I normally have in these hearings is if it's your only copy, what you just gave her, we have to take it. So does that make sense?
I need my baby's one back.
Well, I haven't got to that one yet. I'm just starting with this one. So I really don't know that there's a relevance to this. We have, I don't think there's any evidence that.
You've conceded.
Yes.
I mean, you stipulate to the fact that they're
have a
trying
house
to get
coming.
a modular home
Yes,
there.
yes.
Okay.
So I don't know that this is relevant for this one. As to the information regarding the medical documents, I'm going to object for relevance in terms of the actual document. I accept their testimony. Also, anything that we get becomes public record, and anybody could request a copy of this document, and by law, we have to give it to them. I don't know that they realize that, and so I don't know that they want to.
There's not like
Yeah, we
his,
don't-
I don't know that they want this
We don't wanna
out there.
submit that
No.
So, okay.
there's no social security.
Well, I
checked
checked
all
that, but just, I wanted to caution them, but I would
These are
object to
medical
relevance
records.
for
Yeah, we
both
don't
of
want-
them.
So, I mean,
We just want
if
to
you
get that
want, I would accept them, but you do need to know applicable public records law.
Yeah, I was
There are
I was
exemptions,
actually
but
I'm sorry. I was informed about that. That's why I didn't mind with the medical record because it's
I
already
accept your
known in there.
testimony. I don't need
They
further
don't
proof.
need
I think what you've said is accurate. I have no proof to the contrary, or no evidence to the contrary, so I accept your representations on that, okay? So you don't need to give me the
I mean,
documents.
y'all wanted to keep that. That's for you guys. That's just because that's why we put everything on hold.
Okay.
Is why our son was in the hospital.
Okay.
We literally put everything on.
All right, it's admitted as Exhibit C. It's a document from UF Health. Yeah, all right, so that's a long time to be in the hospital.
Yes, sir. And driving back and forth and working and trying to
And I
hold the
stayed
family
there
together.
and having to take care of a 7-year-old, getting him to school.
The Connex isn't going to stay on the property unless you find a way to convert it. But I don't want to set you guys up for failure because I don't know if that'll ever be allowed. I don't know how long the plans will take, so I can't make a ruling with that in mind. What I can do is, it's a good size parcel. I don't think that it presents an immediate health safety concern, if that makes sense. Mr. McGuire, are you aware of an immediate health safety sanitary concern regarding the Connex?
I think if you were to walk into that, you are really lost.
I think that's a good way of
organized.
putting it. It looks like a good piece of property. It looks like someday it'll be a great piece of property. What's the county's recommendation?
That's $100 a day.
You have 90 days, and it'll be $100 a day if it's not brought into compliance as ordered. Okay? That's a good amount of
And
time.
My question is, if I do get the permits to rectify it into a storage shed with siding and use the
You've got 90
skeleton-
days
I have 90 days to do that, okay.
well, no, I mean, it's not that simple. You need to have the home there. I suspect, actually, let me take that back. First of all, consult a lawyer of your own counsel. What I can say, the only thing I'm holding today is that Connex either has to be gone or properly allowed on the property within 90 days.
That was my question.
Now, it may be that in order to be properly allowed, a bunch of other things have to happen,
Correct.
such as having the home and all that other stuff, but I leave that to you and the county,
Right, thank you,
okay?
appreciate it.
Good luck.
Next case, Christian and Vanessa Burnett, case number 2025-273. Code Officer Alan Jonason, page 8 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Good morning.
Christian Bernate.
Vanessa Bernate.
Very good. All right.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2025-00273, Citrus County Land Development Code, Section 4002, Site Development Without a Development Order or Permit. The address is 6475 East River Road, Hernando, Florida. Property owner is Bernate Christian and Bernate Vanessa. This property is 1.59 acres and is zoned CLRMH and was purchased on 19 September 2024. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 26 February 2025, and an aerial photo from the property appraiser's website from 7 May 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, and a copy of the pre-hearing order.
Can you give me a narrative of what's going on?
Trees were taken down and not a lot of grading was done, but there was a pathway created while they were taking down the trees.
Okay. Let me first ask y'all, are you contesting whether or not there's a violation?
No, we're not contesting. I would like to give like a background of
Yeah.
how we end up here, but
Sir, if you. I don't know that that's necessary, to be honest. They've conceded that there's a violation, so I would love to hear your version of what's happened and what's going on.
Okay, we purchased this property last year in September, around September, and we basically purchased it for like a getaway property, and our plans was kind of start like putting like a RV or modular housing in there, and when I went over there, it was full of trees, so I started kind of cleaning myself, but I gave up, so I just hired a local, basically someone from the same neighbor, to start kind of cleaning.
You've heard some of these cases today.
Yeah, basically it's the same as one of the past case. I told he knew. I mean, it's a big company, tree removal company, licensed and insured, and they knew what they were doing, and this was during the flooding, like on December, so it took a while for them to start, but when they started, they didn't let me know until they were already on there, you know. So when I received this notice, I said, hey, you guys started, and yeah, they already started about a week before I received that notice. So,
I mean, it's not a lot.
No.
You know, you know, of the cases I've seen today, it's probably the least, which I think Mr. Jonason also, kind of represented, but it is there. Yeah. Is there anyone from the public who wants to be heard on this case? I don't see anyone. What's the county's recommendation?
2,500.
Okay. This is 1.59 acres, you said?
Yes, sir.
1.9,
sorry.
Okay. Well, I mean, I think based on your representations, a 1,500 fine is adequate. We have to hold the line of deterrence on it, you know, just to go through the stuff. And you may want to consult a lawyer about remedies you have against your contractor or vendor. Okay?
right, I will do that.
All right. Is there anything else?
No, I will do it.
Good luck with your getaway.
Thank you.
Thank you so much.
Next case, Curwa, Michigan LLC, case number 2025-350, Code Officer Alan Jonason, page 29 of your agenda.
Good morning. I do. Chris Young.
And sir, are you an owner or principal of Curwa, Michigan LLC?
Representative for State Line Construction.
Okay.
Associates.
I mean, so you're not a part of the owner of the company?
No, I am not.
Okay. And in what capacity, I have to ask this in order to establish what your standing is. So did they ask you to be here today?
Yes.
Okay.
I am a manager for State Line Construction, and we were doing some work at that site, and so they had asked me to come out and stand in for them.
Okay.
Like I was telling him earlier.
They want you to take the fall? No, I'm joking. Okay.
Fall on the night.
Let's hear what the county has to say. Please proceed, Mr. Jonason.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 202500350, excessive growth and accumulation of vegetation. A violation of Chapter 20, Article 6, Section 20-60 of the Citrus County Code of Ordinances. Address of the violation is 510 South Little John Avenue, Inverness, Florida. Property owner is Curwa, Michigan LLC. This property is 0.97 acres in a zone CLR and was purchased on 14 August 2020. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 18 March 2025. Photos from my compliance inspection on 8 April 2025, and photos from my final inspection conducted on 19 May 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a photo of the notice of hearing posted on the property, a copy of the pre-hearing notice, and a copy of the posting affidavit. Additionally, there is no Curwa, Michigan LLC listed in Sunbiz.
Okay, so let me ask you this. On a scale of Becker to 10, what level of violation 18 inches or vegetation is this? This is probably an 8. Oh, it's an 8? Okay. 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 So, sir, I think, do you have anything in writing from them designating you as an agent or anything
No, I do not.
today? What I'm going to say is I'm going to allow you to speak as a member of the public, and I want to hear your opinion and knowledge of the property, but I'm not going to ask you your opinion of the exhibits because I don't think you have standing to comment on the quality of the evidence. Without objection, what's been proposed as Exhibits A and B is evidence. Is there anyone from the public who wants to be heard besides Mr. Young, is it?
Yes.
I don't see anyone. Please proceed.
On 18 March 2025, I conducted my initial inspection and observed that the property was in violation. On 18 March 2025, a notice of violation was issued for excessive growth and accumulation of vegetation, which is a violation of the ordinance I mentioned earlier. On 8 April 2025, I conducted my compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 19 May 2025, the property remains in violation.
It could be that Kerwa, Michigan is a non-Florida limited liability company.
I think it's out of Michigan.
I mean, well, I don't know. It might be a place to look. Mr. Young,
It's not in Florida.
I would like to know your knowledge about what's happening on the property.
Okay, my knowledge is that they did send me some pictures, you know what I'm saying, that they was remove the debris, mowed the lawn, but like I was telling him, they sent me a picture of the lawn like half mowed. So I can't show that, it's not completed.
Yeah, the pictures I have appear to be from Monday, I think, and, you know, it looks pretty, I mean, I'd say it's a 7-ish, 8-ish on the scale. Now, Miss Becker, though, she'd bring you know, there's a weed by the fence, one by the fence, a blade of grass that, and then get the ruler out, make sure.
Very thorough.
Called her the hammer. We call her the hammer.
Very thorough.
So in any event, the pictures, I think, speak for themselves. I think your testimony speaks for themselves. What's the county's recommendation?
$150 per day.
14 days to fix the violation, and you said $100 a day?
$150, sir.
$150 if it's not brought into compliance. So please let Kerwa, Michigan know.
Yes.
All right, good luck. Thank you.
Thanks, man.
Next case, Matthew Scott and Billy Joan Kleckner, case number 2025-25. Code Officer Cody McGuire, page 28 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your name, please.
Matthew Kleckner.
Thank you.
Good morning,
Your
sir.
Honor, my wife's not here, she's ill.
Okay, thank you for letting me know. Please proceed.
All right. Cody McGuire, Citrus County Code Compliance Officer, case number 202500025. Violation of Citrus County Land Development Code Section 4002, site development without development order or permit. Address is 9383 North China Pink Way, 1.37 acres in zone CLR. Property owner is Matthew Scott and Billy Joan Kleckner. Good service is signed, certified mail return receipt, and posting at the Kendall Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A is going to be photos I took during initial inspection on January 13th, 2025, corrective action inspection on April 24th, 2025, and pre-hearing inspection on May 19th, 2025, and an aerial photo dated May 24th, 2024.
Sir, before we get into the evidence and everything, you've been here patiently waiting. I just want to ask, are you contesting whether or not there's a violation? Okay. What's the nature, I'll ask you, what's going on?
So he's got a decent-sized piece of property, and there were some trees removed and a fence put up, and that was about it.
What's your understanding?
So
What do you think the violation is?
Cutting the trees without a permit.
Okay. I didn't think fences were...
No, they're not.
The fence was there when I...
Okay.
Oh, was it?
Okay.
I didn't even know it was there.
Well, it
till
wouldn't
I cut
matter.
trees.
Okay. All right. So this is a tree case.
Yeah.
Okay. And are you properly sorry for what you did?
Ignorance is no excuse. I accept responsibility. I hired a land clearing company to clear a place on there for us to build a house. I have in front of me, you have a permit? Yeah, I take care of all permits. I had to leave the state for a while. I came back, had the notice. I called him and said, hey, I wasn't done. Stopped everything. We haven't touched it since.
I get groans from the county every time I do this, but I have to do it once a hearing. You're responsible to know all of this. So It's in reality impossible, but it's hard to have a functioning society unless there is a presumed knowledge or at least responsibility element. So what's the county's recommendation?
I was gonna go for 5K on that one.
You were.
Yeah, but now after just talking to him, I'll go for 25.
Is there anyone from the public who wants to be heard on this case? How big is the property? 1.37. Okay, that's good.
It wasn't all cleared.
No, I understand. It's not Christmas, but I have been doing 1,500 on these, so I'm going to do 1,500 on this one to stay consistent for this hearing and leave it there. Good luck.
Thank you.
Thank you.
Next case, Pedro and Jeanette Estrella, case number 2025-275, Code Officer Julie Wilkinson, page 18 of your agenda.
Estrella? Is it page 18? Yes. Oh, okay.
How you doing? Yes, ma'am. Pedro Estrella.
Jeanette Estrella.
Good morning.
Morning, how you doing?
Good. How are you?
Good.
Okay.
Good. Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 2500275. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 13 North Jackson Street, Beverly Hills. The property owner is Pedro and Jeanette Estrella.
Pretty good. Pretty close.
I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on February 27th, 2025. Photos from a corrective action inspection on March 18th, 2025. And photos from a final inspection conducted on May 19th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
First, I want to ask y'all, are you contesting whether or not there's a violation on the property?
No, I'm not.
Okay.
But I would like to explain some things.
Yeah, well, it's because you're not contesting, I don't think we need to go through the photos necessarily, but I want to give you a chance to let me know what's going on.
Yeah, I would like to say that, send the date of the notice, because this is a rental property that I have. And I got my house back like 4 or 5 years ago, because it used to be run by a real estate. And I wasn't aware that this man, through the years, has been accumulating stuff in the yard. Until even when I got it back, I never bothered looking at it. I just got the rental, or he will bring the rent. And so recently, since I got the notice of violation, I went back and I noticed it and all that. So I told her, hey, you gotta clean this up. So since day one, due to the fact that this man works every day, also recently in November, his wife got sick mentally because of this issue, or maybe because the neighbor always harassing them because of the way they kept the property. So I told him he gotta clean it up. Since the date of notice, he'd be cleaning it up. Due to the job that he have, he only got one day of the week to work in to clean up, and that's what he's been doing. And recently, the last time that I met with Mrs. Wilkinson, she gave me into the 20, but he did clean some of it, but not all of it that it needed to complete, let's say, the job that he had to do, cleaning the whole area. So hopefully it's not much to be cleaned up, and I just want to need a little bit more time to, which I already did, have a lot of time, but since the way he works and the only day he got to do it, and it seemed like it was a lot of stuff in there.
Ms. Wilkinson, has there been improvement?
Yes, there's been a lot of improvement in the property.
Okay. Have you had contact with the tenant or the person in possession?
I had contact with a female tenant. I don't know if that is the
Who they're
wife
talking about,
who had an issue, but she was not happy to see me at all.
Usually that's code from the code compliance officers. I've asked you to be candid, and you have been, by the way. Perhaps too candid on, but tell me what, I mean, is it relevant for me to know?
It's not relevant. She was just saying I'm a weirdo for taking pictures because her children are in the yard, but they were not in my photos.
Right.
So
Right. You weren't taking the photos because kids were in the yard?
absolutely
okay.
not.
So how much time do you think you need?
Well, according to the situation, maybe at least 2 more months, and maybe could be less.
All right, I need to see the photos then. Just because go ahead and share them. Let me know if you have any objection. You've already stipulated to the violation, but I'm going to look at these photos and determine how much time is necessary.
That doesn't look like that anymore.
Well, it changes as time goes on. You'll keep going through the photos. Your last inspection, I assume, was Monday or yesterday?
It was Monday, yes.
Ms. Wilkinson, what is the limit of my power? Are there limits on my power?
You know, I guess it would be limitless until someone tells you otherwise and takes you to court.
That's a very good answer. That's a very good answer. You often find that with issues between different branches of government, and federal, state, local.
Right there, the photos that she previously took is not there, where everything is clear out.
All right, well, let me just take a look, and I don't want to give too much time. I don't want to give too little time. I want to get that right bowl of porridge. So let's just look real quick. You can tell I'm reading a lot of books with my 3.5-year-old. Yeah. There's been a lot of improvement. I don't think it's going to take 2 months. I understand what you're saying about working 1 day a week and that kind of thing, but I mean, is the trampoline's not considered junk, is it?
No.
No, that's a good trampoline. So I'm going to give 30 days. I'm going to give 30 days. And what's the county's recommendation?
It's going to be $100 a day.
Okay, if not brought into compliance as ordered, 30 days. I encourage, if she's, if y'all are having trouble, get help. Just get it done in 30 days. Otherwise, that fine will start to accrue. Okay?
So before the 30 days, I notify you to come and double check again?
When it comes into compliance, please let the county know as soon as possible.
Okay.
Okay? Thanks, guys.
Thank you.
Take care.
Next two cases, Timothy Black, case numbers 2025-311 and 2025-333. Code Officer Erica Olson, pages 10 and 11 of your agenda. Expert on the case, Joanna Coutu, Land Development Director.
I asked the associate attorneys from my office to come today, expecting that they would see some kind of dramatic, Scopes trial or something like that. But y'all have disappointed me. And okay, all right.
I know. That blame is yours to bear.
Why?
You could have created that.
I still could, I guess. I could start pitting y'all against each other, and it's not a bad idea. We might need to get into that. All right. But that's fair. I do have responsibility. You're exactly right. So go ahead.
Erica Olson, Citrus County Code Compliance Officer. This is case number CE 2025-00311. And CE, oh, I'm sorry, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20 through 31 alpha of the Citrus County Code of Ordinances, and case number CE 2025-00333, temporary occupancy of a recreational vehicle, a violation of the Citrus County Land Development Code, Section 3140, temporary uses, Table 3, Tac 2. The address is 1515 South Trellis Drive, Homosassa. This is 1.07 acres and is zoned LDR MH. Property owner is Timothy E. Black, and I have good service via posting on the property and posting at the Lecanto Government Building.
Okay, is there anyone from, I don't see any other members of the public here, so I'm going to stop asking for public input. Exhibits A and B will be admitted without objection. I'd like to see them. Is it A and B in each case? Yes, sir. All right. That's fine, that's fine. All right, looking at the junkyard conditions, photos, they really do speak for themselves. I assume you took the photos on the dates indicated?
Yes, sir.
All right, so what's the county's recommendation on the junkyard conditions case?
$150 a day, along with administrative costs.
I mean, this is terrible, you know, on the junk scale. This is 8 or 9.
There has been some improvement, though.
Okay. Well, I'm still going to give 30 days, and if it's not brought in compliance in 30 days, $150 a day.
Okay.
On the illegal RV occupancy, can you tell me a little bit about that?
So these RVs are parked kind of in the back of the property. I had to use a neighboring property to even view them. There are 2 RVs, from what I can see. One RV has like wooden steps to the RV. There's like personal photographs sitting up by the RV. They have lights strung up. And then the other RV, I've seen individuals come and go from that RV.
You've witnessed that?
Yes, sir.
Okay. I mean,
And leave on their bicycle.
I mean, conceivably, there would be health, safety, sanitary concerns here, correct?
Yes, I mean, I haven't seen that, like, or smelled anything to warrant calling.
I mean, how close did you get?
I was pretty close because they're, like, right up on the property line.
Where's it going?
I mean, they could be taking the RVs out. I mean, I don't know. I haven't had any contact. I did have a case previously that had abated because I didn't realize that all this junk was behind. And in that case, I had contact with someone who said that he was the caretaker of the wife of Mr. Black. But that's the only contact I've had with anyone from this property.
Are they allowed to have the RVs on the property?
They can have the RVs on the property, but I do 100% believe that people are inhabiting the RVs.
How are we going to ever know whether they're in compliance or not?
Well, I mean, the junk could be cleaned up, and they could either, like, they can have the RVs.
Well, forget the junk case. I'm just talking about the RV. How are we
Well,
going
I
to
mean,
know?
like the junk, because like by the RVs, there's shelves. I mean, they have like a lot of their like personal items on there. That's what makes me believe that someone is living in the RVs. So if that stuff were gone, I mean, presumably then perhaps they wouldn't.
Yeah, I mean, but that's side evidence, you know, that's circumstantial evidence, right?
Mhm.
I mean, they could move all that stuff but still be occupying.
Yes, they could.
So I'm a little worried. Split view. Wow. Oh, really? No, I haven't seen it. That's incredible. Okay.
I hate
For-
this.
For RV occupancy cases, I've always had them, a lot of times if we've had contact and they vacated it and gave us access to view the living
inspect.
conditions, then that could abate it.
Okay. Well, look, I mean, the bottom line is I'm satisfied there's a violation. I'm just concerned about enforcement. So that's really something that can be dealt with downstream. What's the county's recommendation on this case?
$150 a day. With
Okay,
administrative costs.
I'm going to give them 10 days, and if it's not brought into compliance in 10 days, I'm sorry, $150 $150 a day.
Thank you.
Thanks. I gave 30 on the junk, 10 on this one.
Thank you.
Next case, David A. Braisky, case number 2025-515, Code Officer Erica Olson, page 13 of your agenda.
by the way, y'all are welcome to continue watching. Don't feel obligated. There's other action in the courthouse as well, or if you have other things like, lunch to get, just FYI. But, all right, go ahead. No, I mean, they can search. I told them about it. They can find it if they want. It's a jury trial? Yeah, it was a jury trial. On the animal case? Okay. Well, there's something interesting going on in the courthouse, so. All right, please proceed.
Erica Olson, Citrus County Code Compliance Officer. This is case number CE 202500515, accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20 through 31 Alpha of the Citrus County Code of Ordinances. The address is 6950 West Sedate Court in Homosassa. Property owner is David Brasky. I have good service via signed certified mail receipt and posting at the Lecanto Government Building.
Okay. Your exhibits?
Yes. Exhibits A are photos taken during my initial, do you want me to go through the whole thing? Or?
Not really.
Okay, cool. Photos and then the...
All right, exhibits A and B are admitted into evidence without objection. I will briefly review them. You took the photos on the dates indicated?
Yes, sir.
Okay. Have you had contact with the owner?
I have not.
It looks like they're trying. Is that a rooster?
I did not see a rooster, so I don't know. I did not see that.
Okay.
I know.
So they got to get rid of everything that's in that trailer
Mm-hmm.
and some other stuff. I mean, it's well mowed.
Yeah, it's not horrible. It's
That's
the trailer full of
there's a
garbage.
bunch of disgusting
and
stuff
There's
in
some
that trailer.
tires. Yeah.
I do see the tires. All right, what's the county's recommendation?
We request $100 per day with administrative costs.
All right, we'll do 15 days and $100 a day.
Thank you.
Thank you.
Next case, Michael J. Clark, case number 2025-269, Code Officer Julie Wilkinson, page 14 of your agenda.
Julie Wilkinson, Citrus County Code Compliance Officer. Case number 2500269, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 82 South Lucille Street in Beverly Hills. The property owner is Michael J. Clark. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, inspection photos from February 26th, March 13th, and May 19th. Exhibit B, copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
Okay. Without objection, what's been proposed as exhibits A and B is evidence. I will take a look. You took the photos on the dates indicated.
Yes, sir.
Contact with the owner?
Yes, I have had, yes, I have had contact with the owner.
And have they indicated an indication that they'll take responsibility or that they need a certain amount of time?
She said they were in the middle of cleaning up the property because, as you can see, there was a dumpster there and that they would take care of it all, and which the dumpster got removed, some of the junk got removed, but not all of it. And I haven't had contact with her since, even after sending the notice of hearing.
Yeah, there's a large quantity of stuff to be removed, but it's not like an impossible task. It's not the kind of case where there's junk everywhere. It's kind of aggregated, and I'm going to give 15 days. And what's the county's recommendation on the fine?
$100 a day.
$100 a day.
Thank you.
Thanks.
Next case, Suzanne Evans, case number 2025-295, Code Officer Julie Wilkinson, page 19 of your agenda.
Julie Wilkinson. Just a quick, do I have to say that every time? Julie Wilkinson? Oh, okay. All right. Case number 2500295, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 524 South Harrison Street, Beverly Hills. Property owner is Suzanne Evans. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they to be admitted into evidence. Exhibit A, photos taken during an initial inspection on February 28th, 2025. Photos from a corrective action inspection on March 25th, 2025. And photos from my final inspection on May 19th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
Exhibits A and B are admitted as evidence. I will take a quick look. Wow, you're giving me some easy cases.
Oh, yeah. You're welcome, by the way.
Yeah, I mean. Okay, I mean, you took the photos on the dates indicated?
Yes.
Contact with the owner?
No.
Okay. True. What's the county's recommendation?
$100 per day.
15 days, $100 a day.
Thank you.
Next case is, they're all separate addresses? Oh, okay.
They're not all the same property?
Separate addresses, yeah. Next case, Fifth Seven Construction Group LLC, case number 2025-397. Code Officer Julie Wilkinson, page 20 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Is it the same violation on all the properties?
Yes.
Almost, okay.
There's one outlier.
Gotcha.
Oh,
All right.
yeah, that's
I'll
true.
let y'all present them how you want to.
Okay. Case number 2500397. Special requirements for all accessory uses, a violation of Citrus County Land Development Code 3102A. The address is 8413 North Boulder Drive, Citrus Springs. Property owner, Fifth Seven Construction Group, LLC. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken from an initial inspection on March 19th, 2025. Photos taken during a corrective action inspection on April 17th, 2025. And photos from my final inspection conducted on May 19th, 2025. Exhibit B, a copy of the notice of hearing, notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
Exhibits A and B are admitted as evidence. Can you give me a narrative?
Yeah, so it's a vacant property. There was which a building permit was issued, but it did expire on August 3rd, 2024, and no CO was issued. That's where we're at. So there should be nothing there. Either I have a Joanna Coutu, the expert on the case, is here.
So all the cases are similar to me. I'm not even aware of the outlier, but they all were issued in 2023 for single-family home permits. In 2024, they let them drop. They got through partial inspections and then disappeared. 2024, every single one of them have expired. So now there's a use, but not anything current that allows that use.
Ooh, this is...
There's a structure there. It's not complete.
And it
but-
was built pursuant to an issued permit. It was...
Parts. They started failing inspections, and that seemed
Oh,
to
I
have
see.
triggered, I don't know. I don't know why.
So the county, what does the county want in this case?
Either to tear down the structure or to get a new permit issued and
Do they need a permit to tear down the structure?
a demolition permit, yes.
I'm having trouble with this because the code section that I'm looking at says, storage. This is the principal use, you know?
Yeah, it's not established, though.
I think the county's position at this point is the items on the property are just being stored there because there is not a principal use.
I get the
There's
county's
no
case.
CO.
Yeah, I get it.
So at this point, even though it looks like a house, it looks like a building, it's just storage of construction material on that property. And that is not permitted by our code.
I'm not going to say the county's wrong. It seems to me honestly viable, but is there any other section you could have brought based on an expired permit and construction that just doesn't get finished? Like, is this it? I'm just curious.
The only problem with, even if we were to do ATF, when it was constructed, they had the permit.
Right, and I had dismissed that kind of case before because I didn't. No, so that's what I'm wondering. I mean, if this, maybe this is your only remedy. All accessory uses, regardless, shall be allowed once a permit is issued and meets the following requirements. Prior to the establishment. Okay, what's the county's recommendation?
$100 a day.
All right, so they can abate this only by getting some kind of a permit, basically, and
Yes.
removing or getting back on the horse.
Yes.
And when was your first notice given in this case?
The first notice violation was issued on March 20th, 2025.
Any contact with the owner?
No.
Okay. All right, then I'm gonna give 30 days, and if not brought into compliance within 30 days, $100 a day.
Thank you.
Next case, Fifth Seven Construction Group LLC, case number 2025-398, Code Officer Julie Wilkerson, page 21 of your agenda. Expert of the case, Land Development Director Joanna Coutu.
Case number 2500398, special requirement.
Repeat the case number,
Okay.
he just said it.
This address is 8405 North Boulder Drive. It's exactly the same, just next door.
Can I look at the exhibits?
Yes.
They're admitted without objection, exhibits A and B. You want to reincorporate the testimony from the prior hearing?
Yes, please.
Okay. Okay, I mean, you took the photos on the dates indicated.
Yes, except for the posting, the director of
Okay.
code compliance took that
All
photo.
right, thank you for letting me know, and no contact with the property owner.
No,
All right, 30 days, $100 a day.
thank you.
We have two cases we could do together, 399 and 431. They're the same address.
Okay.
If that's okay, you good with that, Julie?
Yeah, which numbers? Yes, 431 and 399?
Yes.
Absolutely.
Fifth Seven Construction.
Yes.
So for case number 399, it's exactly the same as the previous two cases. However, case number 24002500431 is a lawn case.
Got it.
The address is 8397 North Boulder Drive.
All right, can I see the exhibits, please?
Yes.
All right, we'll
We would
do
also
that.
incorporate-
We'll incorporate the testimony regarding the, I'd say, the process behind the LDC violation. And exhibits A and B in each case are admitted with no objection. Respondent has failed to appear, and there is no one from the public to be heard on this case. What is, well, you took the photos on the dates indicated in each of the Exhibit As?
Yes.
And no contact with the property owner?
No contact.
What is the county's recommendation in each case?
$100 a day, please.
All right, in the unkempt lawn case, I will grant 10 days to bring it into compliance. If it's not brought into compliance as ordered, $100 a day. Storage on a vacant parcel case will be 30 days to comply, and if it's not brought into compliance as ordered, $100 a day.
Thank you.
Thank you.
Fifth Seven Construction, case number 2025-459, Code Officer Julie Wilkinson, page 23 of your agenda. Expert on the case, Joanna Coutu, Land Development Director.
Okay, the address for this case is going to be 6683 North Tassel Terrace. Again, everything is going to be the same except different inspection dates. Would you like me to go through those dates?
I think it'll be shown in your photos, probably, so. I'll admit exhibits A and B as evidence. No objection.
And we'd also incorporate the prior testimony in this case as well.
Yes. And did you take the photos indicate on the dates indicated in Exhibit A?
In Exhibit A, yes.
Are those reflective of the dates of your inspections?
Yes.
Did you have contact with the property owner?
No.
Okay. Yeah, I mean, I think your legal theory is correct. I will grant 30 days and $100 a day if it's not brought into compliance.
Thank you.
Next case, Guillermo Hernandez and Ariana Alvarez, case number 2025-331, Code Officer Alan Jonason, page 25 of your agenda. Land Development Director, expert on the case, Joanna Coutu.
Alan Jonason, this is case number 202500331, Citrus County Land Development Code, section 4002, site development without a development order or permit. The address is 2801 East Possum Court, Inverness, Florida. Property owner Castano, leader Guillermo Hernandez and Alvarez Ariana Quina. This property is 2.15 acres and is zoned RURMH and was purchased 1 August 2024. I have photos of the site. I've had contact with the property owners. They're very apologetic. They travel for work around the country. I can present the pictures and then we can discuss
see 'em.
what we,
Yeah.
put in a couple.
Okay. Exhibits A and B are admitted.
They also put in a couple driveway aprons that will be a part of our request for the assessment. In other words, we're asking for a one-time fine, $5,000 for the property, and then we'd also ask they remove the driveway aprons in a specific amount of time or incur a fine of $200 a day.
Do they not meet code, the aprons?
They've never been permitted. They just did it. And they can't do it, from what I understand, without a building permit.
I mean, usually that's the case, but
Yes, sir.
they look like they might pass code. I don't know. So it does. I mean, I honestly don't know.
You can't issue it for a vacant lot, so they may, but that would be part of a site review for a primary structure. They have to restore the right-of-way to the previous condition because there's no use there.
So y'all won't approve driveways?
When there's no established use, correct.
Really?
Yeah.
Okay.
Because people camp, as you know.
Well, when I mean, don't don't they need to be able sometimes to go do inspections and surveys or to get trucks on there sometimes?
Not with a visible constructed apron, no, not until they're ready to do something.
Wow, okay. Well, what's the county's recommendation on the fine?
So a one-time fine of $5,000 and then a daily fine after your assessment of a time for them to abate. I would, in my personal opinion, 90 days would probably suffice to remove the aprons. And if they're not, then a $200 a day fine.
I'll assess the one-time fine you're requesting.
5,000.
As to the driveway,
And there's two of them there on the property.
I see. It's just, you know, most of the time when they do something like an improvement, I don't think you've always required that it be removed or asked me to remove it, right? Like when there's gravel paths on the roads. Have you requested removal of like gravel
Yes, sir.
paths? Okay, not just
Absolutely.
one-time fines?
Absolutely.
Okay. That was, I mean, there was a bunch of stuff that happened in Data Holdings. Well, it doesn't take long to do that. Okay, I mean, I'll give them 90 days to remove it, and if it's not removed within 90 days or otherwise permitted as part of a, you know, a lawful, you know, development, then $100 a day.
Thank you.
Okay.
Next case, Cynthia L. Key, case number 2025-382, Code Officer Erica Olson, page 27 of your agenda. Expert on the case, Joanna Katu.
This is a repeat violation initially observed on the 17th of March, 2025. This is case number CE 2025003. Really? Because I'm like right in the microphone. I feel like it's really loud. I feel like I'm yelling. Okay. Now I lost my spot. This is a violation of special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102 Alpha. Property owner Cynthia L. Key has previously been found guilty of the same violation at the same location on the 21st of June, 2023, with a fine of $396 imposed after lien forgiveness of $17,585.29. The address is 4936 South Roebuck Way, Homosassa, 0.21 acres and is zoned MDR MH.
Okay, I'd like to take a look at the exhibits.
Okay. Exhibit A is the paperwork from the previous case, and then B is the photos, and C is the paperwork.
All right, exhibits A through C are admitted as evidence. I'll just quickly look through them. This is a case I don't actually remember. All right, so did you take the photos on the dates indicated?
Yes,
Have you had contact with the owner?
I have. Let me look at the date. I spoke to her on the 16th of April, and she requested another inspection. I went out there on the 17th and found that it still remained in violation. The RV and the shed were still there. She did say she was trying to sell the RV, but as of my inspection on the 19th, the items still remain.
Why did she call you out? I mean,
She said that significant improvement had been made. That wasn't really the case.
can you give me the timeline here regarding, you know, the discovery and what you'll ultimately be requesting with the fines?
Yes. On the 17th of March, an inspection was conducted and photos were taken regarding a complaint of storage, which is a violation of the above-mentioned ordinance. During this inspection, I observed that there was an RV, vehicles, a shed, and some miscellaneous junk and debris on the property. On the 20th of March, the property was posted with an NOV and NOH. I spoke to Key on the 16th of April, stated that significant progress had been made. I went back out on the 17th, found that wasn't the case. I never received a call from Key advising me that the RV had been sold. On the 5th of May, I conducted another inspection and found that everything still remained and it was still in violation. She actually came out of the RV that day to talk to me. She said that somebody was supposed to come and look at the RV, but they never showed up, and that's why it still remained on the property. When I returned to the office, I called her and left her a voicemail advising her again of the date of the hearing. And on the 19th of May, I conducted my final inspection and the property remains in violation.
Okay, so what's your request?
My request is that the special master assess a fine of $150 per day with administrative costs to begin after the date of posting on the property, the 20th of March, 2025, and continue until the 20th of May. That would be 66 days at $150 per day, totaling $9,900, and a fine of $200 a day per day from this day forward until the violation is abated.
Okay, I find that the property is in violation, assess a fine of $150 a day from the period of the first posting, i.e. March 20th through yesterday. For a period, I'm going to, you said it was 66 days? Did I get that right? That can't be.
Yes.
Well, I'm not going to make a finding as to the number of days, but I'll say it's from March 20th to May 20th, and then $200 a day from today's date forward.
Thank you.
Okay, thanks.
Nona Vision Corporation LLC, case number 2025-402, Code Officer Julie Wilkinson, page 34 of your agenda. Expert on the case, Joanna Coutu.
Did you say 400?
What? All different properties.
Yeah, number 400 we're doing first. Okay. This is case number 2500400. Special requirements for all accessory uses. A violation of Citrus County Land Development Code 3102A. The address is 3286 West Eunice Drive in Citrus Springs. The property owner is Nona Vision Corporation LLC. Have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request it be admitted into evidence. Exhibit A, photos taken during an initial inspection on March 19th, 2025. Photos taken during a corrective action inspection on April 17th, 2025. And photos from a final inspection conducted on May 19th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
Without objection, what's been proposed as exhibits A and B are evidence. Thank you. All right, so you took the photos on the dates indicated.
Yes, except for the posting photo.
Have you had contact with Nona Vision at all?
No.
What's the county's recommendation?
$100 a day.
So is the case here that they never had a permit or just that it's expired?
This one had a permit which expired on November 2nd, 2024, and no CO was ever issued.
I would hope not. All right, so I'll grant 30 days and $100 a day.
Thank you.
Next case, Nona Vision Corporation, case number 2025-400, Code Officer Julie Wilkinson, page 35 of your agenda.
That was page.
Did I skip one?
No, well,
Yeah.
she presented the one on page 35.
Oh, okay.
So we should do 401?
401, page 33 of your agenda. 30.
That's 402?
401.
I have it, okay, I don't,
Oh.
that's fine. 401 is good.
Okay. Case number 2500401, special requirements for all accessory uses, a violation of County Land Development Code 3102A. The address is 3204 West Eunice Drive in Citrus Springs. It's the same as the previous case, just next door.
All right, let's take a look.
I have 3274.
Yep. All right, so exhibits A and B are admitted as evidence. I will take a look. I assume this is an expired permit.
Yes, this permit also expired on November 2nd, 2024.
You took the photos indicated? On the
Yeah.
dates indicated, I should say?
Yes, except for the posting.
Okay. No contact with Nona Vision?
No.
All right, then I will grant 30 days to abate the violation, and it'll be $100 a day if it's not abated.
Thank you.
Next case, Nona Vision Corporation, and we're at 402, right?
Yes.
And case number 2025-402.
This case is also a storage on special requirements for all accessory uses, violation of County Land Development Code 3102A. The address for this case is 3262 West Eunice Drive. Everything else is the same.
All right. Exhibits A and B are admitted as evidence. And did you take the photos on the dates indicated in Exhibit A?
Yes.
This one's worse.
Mm-hmm.
Okay. Any contact with the owner?
No.
All right, I'll grant 30 days and $200 a day.
Thank you.
Next case, Craig Price, case number 2025-340, Code Officer Julie Wilkinson, page 37 of your agenda.
Case number 2500340. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 525 South Jackson Street in Beverly Hills. Property owner is Craig Price. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on March 5th, 2025. Photos from a corrective action inspection on March 21st, 2025. And photos from a final inspection conducted on May 19th, 2025. Exhibit B, copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
These exhibits are admitted without objection, and I will take a quick look at them. You took the photos on the dates indicated?
Yes.
This is a 3.5 or so. What's the county's recommendation?
$100 per day.
Any contact with the owner?
Yes. He was very nice. chill dude, chill person, Mr. Craig Price was.
Dude is accepted, it's accepted vernacular at these hearings, so.
Uh, and he did work on a little bit, but then I don't know if he thought I was not coming back, because then stuff started coming back out again, but it's not that bad.
It doesn't look that bad. I don't think it should take him that long. I'm gonna grant 15 days, and if it's not brought into compliance in 15 days, $100 a day.
Thank you.
Thank you.
Next case, Raymond J. Schmidt, case number 2025-287, Code Officer Alan Jonason, page 39 of your agenda, expert on the case, Land Development Director Joanna Coutu.
Alan Jonason, Citrus County Code Compliance Officer, case number 2025-00287, special requirements for all accessory structures, a violation of Citrus County Land Development Code, section 3102. Address is 3199 East Buffalo Lane, Hernando, Florida. Property owner is Schmidt Raymond J. This property is .16 acres and is zoned MDR-MH and was purchased on 1 July 2010. Good service via posting the notice on the property and posting at the Lecanto Government Building. Exhibit A and Exhibit B are photos and administrative paperwork.
Okay. Exhibits A and B are admitted without objection. Okay. And did you take the photos on the dates indicated?
Yes, sir.
Contact with the property owner?
No, sir.
It's supposed to be vacant.
Yes, sir.
Okay. We started this case a while ago, so I guess, Have you seen anyone on the property?
I have not seen anyone on the property.
Because
but
it looks like at one point, there was even a door open.
Right.
Huh. And it's not a big
I
property.
think it changes because there's different vehicles that are brought in and then removed and.
I see cats. Well, what's your recommendation?
$200 a day.
All right, I'm gonna do this one at 15 days and $200 a day, just because it looks like all that stuff is eminently movable.
Thank you.
Thank you.
Next case, Jose Luis Soto and Unia Alvarez, case number 2025-337.
Bless you.
Code Officer Julie Wilkinson, page 40 of your agenda.
This case number 2500337, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 165 West Greenbrier Place, Citrus Springs. The property owner is Jose Luis Soto and Unia Alvarez. I have good service via posting the notice of hearing at the property and at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on March 6, 2025, photos from a corrective action inspection on March 21st, 2025, and photos of my final inspection conducted on May 19th, 2025. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, photos of the notice of hearing posted at the property and a copy of the posting affidavit.
All right, exhibits A and B are admitted without objection. Thank you. I will look through them quickly. You took the photos on the dates indicated.
Yes, except for the posting photo.
Contact with the owner.
No,
Anybody?
no,
What's your recommendation?
$100 a day.
Oh, it looks like they brought a dumpster out.
Mm-hmm.
Okay, 15 days, $100 a day.
Thank you.
Thank you.
Next case, Southern Tree Service LLC, case number 2025-240, Code Officer Alan Jonason, page 41 of your agenda, expert on the case, Land Development Director Joanna Coutu.
Alan Jonason, Citrus County Code Compliance Officer, case number 2025-00240, Special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102. Address is 3236 North Florida Avenue, Hernando, Florida. Property owner is Southern Tree Services LLC. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. Exhibit A is photos taken during my inspections, and Exhibit B is the administrative paperwork.
All right. Exhibits A and B are admitted without objection. And Mr. Jonas, you took the photos on the dates indicated?
Yes, sir.
Any contact with the property owner?
I have had contact with the property owner. Matter of fact, I spoke to him yesterday. He wanted to be here today, but his child is graduating kindergarten today. And so that took precedence for him. And he wanted me to ask if he could have an additional 120 days. I think he's working with us to get a permit for this, but I don't know the logistics and specifics of that.
Well, tell me what,
So there's tree debris on the property, and there's also heavy machinery on the property. There's some pictures in there that I got yesterday. There's a bulldozer on there. They've got it's a tree service company. I believe they're storing their tree service equipment on that property. There's storage containers that I could just see a corner of.
I'm not inclined to give 120 days. What's the county's recommendation?
$200 a day, along with the administrative costs.
Is this residential?
No.
What is it?
It's, I didn't write it down.
It's industrial.
Industrial, that's right.
So what would they need to do to bring this into, assuming they wanted to keep the stuff on the property, what would they need?
They applied last Friday for a site permit for a laydown yard for themselves. Came in last Friday, so it hasn't been reviewed yet. They've also applied for an after-the-fact pole barn, but we don't have any plans submitted, so we don't really have an application moving forward on that.
But if it's just a pole barn, that doesn't normally, there's no engineering required for that, is there?
There is.
Oh, there is?
If it's a prefab, they do give us the prefab engineering.
Okay.
Yeah.
But it's not a complicated review, I imagine.
It's not usually, but the use itself, because this is vacant or should be vacant, is a little tricky. They're going to have to do stormwater. An engineer is involved here, but again, it just came in.
Well, those are indicators of good faith and wanting to actually do something with the property after the fact, good faith, I should say. Normally, people who are involved with this kind of use of property really should know better. So I'm not, and it looks like your first inspection was in February.
Yes, it took a while get the research done and find out which direction we were going to go with it.
Well, when do you think they were on notice about the case?
I'm not sure what day I got good service. I'd have to look
Let's see. I've got.
I don't have the NOV.
The NOV says is dated March 31st.
So it was probably 10 days after that we received good service, because I did get good service on the notice of violation as well. And again, he's been in contact with me the entire time. And if you look at the picture in the front, they have removed some of the tree debris or relocated it, or it's not there.
How big is the property?
It's 12.3 acres. All along 41, so very visible.
I see. Well, what's the county's recommendation?
$200 a day, and then the property owner requested 120 days to finalize the permitting. That's what he wanted me to present on his behalf.
So I'm just doing some internal calculations here. Well, I guess the point is compliance. But I'm going to give 90 days, and if it's not brought in compliance in 90 days, $200 a day.
Thank you.
Yep.
Next case, Bobby Ray and Judith S. Triplett, case number 2024-1497, Code Officer Cody McGuire, page 43 of your agenda. Expert on the case, Joanna Coutu.
Summarize it.
Well, tell me what you got.
So I have case number 202401497. It's for special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. The address is 5790 West Amon Street in Denellen. It's zoned RURMH, and it's 2.70 acres. I have
This is
good,
just down the street from another case we had today.
literally.
Okay.
Yep. I have good service, signed, certified mail return receipt, and posting at the Kento Government Building. I'd like to authenticate the following documents and request that it be admitted into evidence. Exhibit A, photos taken during initial inspection on August 23rd, 2024, corrective action inspection on April 24th, 2025, and photos of my final inspection on May 19th, 2025. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the signed certified mail receipt, and a pre-hearing order.
Okay, then exhibits A and B are admitted without objection. And you took the photos on the dates indicated?
Yes, sir. And I've been in contact with the property owners and their daughter. They are diligently trying to get it removed. They were told by the sheriff's department that since the owner is deceased, it would be a hard time having a tow company remove it, and they don't know what they can do civilly.
Well, let's start at the beginning. So the first photo here is from August of last year. What took so long?
My fault.
Okay, so it's just an old case.
Mm-hmm.
And the owner's deceased?
Of the RV that's on the property.
I mean, is that, I see two names here, Bobby Ray and Judith Triplett. Are
They're
they
not
both-
the owners.
They're not the owners?
Mm-mm. Of the RV.
Oh, okay, they own the property.
They own the property, but not the RV.
And you mean to tell me that they don't think they have the right to move that?
I think they're confused on their rights.
I mean, no one at the sheriff's office told you that, correct? No lawyer has told you that they can't remove that.
No.
Okay, it's just what they told you.
Mm-hmm.
Okay. I mean, I think that's a really interesting restatement of Florida law, because if someone just parked their car on my property, I assure you I can get it removed. Did they ask for an amount of time?
At least 60 days.
No. Nope. Has it moved since August?
Somehow it got backed up.
It did,
Yeah.
somehow.
It's very strange. And it's more secured, too.
It's not strange.
It's not, no?
It's not strange. It didn't happen by itself, I can tell you that.
I wished it would have moved off the property.
Yeah, right. Well, what's your recommendation?
Since I've been in contact with these people since, I just did $50 a day.
Yeah, well, you've been in contact with them, but they're stringing you along, and it's going to be 10 days and $100. And that's being nice.
Yes, sir.
Let them know. I mean,
Next case, United Investment Holdings LLC, case number 2025-339, Code Officer Cody McGuire, page 44 of your agenda. Expert on the case, Joanna Coutu.
All right, Cody McGuire, Citrus County Code Compliance Officer, case number 202401497, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. Address is 7756 North Chalet Avenue, Christian River, zone OUR, and it's 1.33 acres. Property owner is United Investment Holdings LLC. Good service is signed, certified mail return receipt, and posting at the Canton Government Building. I'd like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during initial inspection on March 10th, 2025, corrective action inspection on March 25th, 2025, and my final inspection on May 19th of 2025. And then Exhibit B is all of the copy of the notice of violation, notice of hearing, signed certified by return receipt, and a pre-hearing order.
Exhibits A and B are admitted without objection. Have you had contact with any representative of the owner or anything?
No, sir, I have not.
Okay.
I've never seen anybody at the property either.
Okay. Did you take the photos on the dates indicated?
I have.
That's an interesting structure.
What is it?
Yeah, that's a good question. I mean, it could be a lot of things.
It could be a lot of things, but
It looks like maybe it was intended to be some kind of,
like a covering, an awning,
I want to say like an animal storage or something. I mean, I don't
kind
know.
of weird. There's some heavy duty lumber in there too. And then all the junk that's next to it, those bottles and
Yeah. Well, what's your recommendation?
that's going to be $100 a day with administrative costs.
It was signed for?
Mm-hmm.
Okay, 30 days, $100 a day.
Thank you.
Last case, Pamela Henley Weiss, case number 2025-159, Code Officer Erica Olson, page 46 of your agenda.
This is a repeat violation initially observed on the 3rd of February 2025. The address is 6051 South Hancock Road in Homosassa. It's a violation of accumulation of junk and debris, Chapter 20, Article 3, Section 20, Tac 31 Alpha of the Citrus County Code of Ordinances. The property owner, Pamela Henley Wise, was previously found guilty of the same violation at the same location with $0 in imposed fines, and that case was abated on the 25th of March 2024. That case number is CE 2023-00705. I have good service via posting on the property, posting at the Canto Government Building, and then I also had a verbal conversation with the property owner's daughter, because the property owner is deceased. This was originally scheduled to go to the hearing in March. She requested that it be moved to May so that she could attend. Exhibit A, the findings of fact and the order acknowledging compliance from the previous case. Exhibit B, photos I took during my initial inspection on the 3rd of February, my subsequent inspections on the 5th of February, 12th of March, and 5th of May, and photos of my final inspection on the 20th of May. And Exhibit C is a copy of the NOV that NOH posted, a copy of the general pre-hearing order, a copy of the NOV NOH posted on the property, or picture, the posting affidavit, and a copy of my log notes indicating a conversation between Haley, the daughter, Wise, and I, and a copy of the continuation letter.
Okay. Exhibits A, B, and C are admitted without objection. I'll take a look at them. Do we still have an alternate special master? No. Okay.
Are you trying to leave?
No, I was just well, when I look at these orders, I wonder sometimes before I see them, is it me? And because I know that we had an alternate who did have some hearings, and it just. Wait, I'm sorry, what? He was at 2 hearings, right? Okay, let me just quickly look. Back when I was the alternate, I got called up from the bullpen more often. You know, in any given year, I might have 4 hearings or something like that. So, let's see. And what I'm looking at in the prior order is, you know, did the person show up and what happened? And Okay. Now looking at the photos. Did the daughter indicate that they were going to undertake remedial measures, that they were going to fix it, you know?
I think she like lives out of state. She doesn't live close, and she said that she was going to try and get someone to help her clean up the property. As you can see, it's not horrible on this scale. I mean,
Yeah.
there's a couch and
Right.
there's like some garbage like kind of away from the house.
Yeah, I'm more worried about the structure of the house, to be honest, but.
That would probably be the next step.
Let's see. How did the daughter get notice?
When I posted the property, I think someone must have told her that the property was posted.
Is this the first time the county's introduced log notes?
I am not sure.
Okay, it's the first time I've seen them, but interesting.
Sorry, it's so small.
Who? Really? I don't ever recall them. I'm not saying she didn't, but I'm interested.
Sorry, it's so small. It's
No, I can
the
read.
best I could
can read.
do.
No, it's fine.
Hmm?
Yeah, they're evidence.
Yeah, I entered them. Just to show I had that conversation.
Oh, okay. All right. So I do think the photos speak for themselves. You took the photos on the dates indicated.
Yes.
You've done your due diligence. What's your recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day with administrative costs to begin the date of posting on the property, the 5th of February, and continue until the 20th of May, which would be 104 days and 100 a day, totaling $10,400, and a fine of $150 per day from this day forward until the violation is abated.
Okay, so I'll assess a fine. I'll find that's a repeat violation, assess a fine of $100 a day from the date of first posting, February 5th through yesterday, and from today's date forward, a fine of $150 a day until abated. I think that's it.
Thank you.
Okay. Are there any other cases? Okay, then just a couple things. We're going to be here for the foreseeable future. Except for September. And let's see, are the case resolutions thing, like as a mechanism, working for code compliance? I mean, do you want to keep continuing that practice at the hearings? I think they've saved time. They don't always save time, but I think in general they're saving time. Yeah, I can't believe that we're, you know. Yeah, okay, good. Okay, good. And let me see. I guess because we're here, everyone has to stay. No one can escape, or I don't know. Is there anything else y'all need from me? Okay, the time is 11:58. This hearing is adjourned.